We'll call the meeting to order. Good afternoon and welcome to maybe the last, if the Moines are right, monthly meeting of the City of Des Moines Zoning Board of Adjustment. This board has the power under Iowa law and the zoning ordinance of the City of Des Moines to hear requests for variances and exceptions from the regulations in the zoning ordinance, conditional use permits, and appeals from the decision of the staff in the administration of the zoning ordinance, and to make decisions in such matters. This is an open and informal meeting currently being recorded. The board members have received a copy of the agenda and staff report and recommendations. Copies of these are available on the trays on my far left and right near the door. We'll have a full 7-member board, and I'll start on my right. Brooke Rosenberg. Next to him is Cindy Smith. Next to her is Tom Clark Sr. On my left is Jake Christensen. Next to him is Mel Pins. Next to him is Linda Westergaard. My name's Bill Gray. Representing City Legal today on my left is Michael Kelly. Representing city staff, we have Eric Lundy, the city planner, Bert Drost, city planner, Sue Ann Donovan, the zoning enforcement officer, and I didn't see Manny. Is he here today? Our TV star is gone. Okay. The board is required to base its decision in each case upon the criteria established by law for the type of relief sought by the applicant. The law applicable to each case is identified in the written staff report. If the facts as determined by the board demonstrate that the criteria established by law for granting the relief have been satisfied, then the board must grant the relief. Otherwise, the board must deny the relief. All speakers are requested to focus their comments upon those facts that demonstrate whether or not the criteria established by law have been satisfied. Each appeal will be announced in order, and the staff will present a brief explanation of the appeal. Any written comments received by the staff prior to the hearing will be distributed to the board or otherwise identified. All speakers are requested to speak from the podium over here on my right and to begin their presentation by giving both their name and address. The applicant or representative of the applicant is allowed to speak first and will be allowed 10 minutes to present their appeal. Anyone else present in support of the appeal will then be allowed 5 minutes each to present his or her comments. Anyone present in opposition to those appeals will then be allowed 5 minutes each to present his or her comments. The applicant then will be allowed 3 minutes for rebuttal or other closing comments. The meeting will then be closed to public comment, and the board will deliberate the request and make a decision. If your appeal is approved, we ask that you wait until tomorrow to go to the Permit and Development Center to apply for any building permits. That's a new one on me, Bert, caught me. Items listed on the consent portion of the agenda will not be individually discussed and will be considered for approval in accordance with the recommendation in the staff report unless an individual present or a member of the board requests that the item be removed from the consent agenda and separately considered under the public hearing agenda. The decisions of this board can only be appealed to the Polk County District Court. If you believe you have been harmed by an error made by this board, your only remedy is to seek relief through the district court within 30 days of the filing of the board's decision and order. If you believe the zoning regulations applied by this board are wrong, you may petition the City Council to change those regulations. All materials written or otherwise used today as part of any presentation will become a permanent part of the record and will not be returned. If you have cell phones out there, we ask that you turn them off or at least put them on vibrate because they're pretty disruptive to the process here. We will be taking a short break around the 3 or 3:30 time frame if needed. As I mentioned, we have a consent agenda. It consists of 3 items. Item 1 is an exception at 2423 40th Street. Item 2 is an exception at 2914 East 41st Street. And item 3 is a special permit at 2507 University Avenue. As I said, these items we're going to vote on as one block, and we're going to vote in conjunction with the staff's recommendation. Is there anybody here present that is here to speak against items 1 through 3? Okay. Anybody on the board need to have those removed? Hearing none, I'll listen to a motion.
Mr. Chair, I make a motion to accept the exceptions and special permits requested for approval on items 1, 2, and 3, subject to staff recommendations.
There's a second?
I'll second.
Been moved and seconded. All those in favor, raise your hand and say aye. Motion carries 7-0. So if you're here for items 1 through 3, they've been approved. And if you'd be kind enough to wait till tomorrow and get your permits, we'd like to see us start improving the area. Thank you. Item 4. This is remanded back to us from City Council from last month. It's reconsideration of a variance to separation requirements at 3804 Hubble Avenue. And we have a communication on that. Did everybody see that? Okay. Bert?
Mr. Chair, members of the board, Bert Ross, planner for the city. This item is for the board to decide whether or not to rehold a public hearing on it. If the board chooses to rehold the public hearing, that would be at the regularly scheduled January 23rd meeting. If the board declines to reopen the public hearing, then the decision from the October 24th meeting would become effective today. So, as you recall, back in October, the board considered a request to have a liquor store at 3804 Hubble Avenue. The conditional use permit to allow the liquor store required 2 variances to be granted. One was a variance of the provision that requires at least 500 feet of separation from any park, church, school, or daycare. And the other is the provision that requires at least a 1/4 mile of separation from any other establishment selling packaged liquor. The board granted both of those variances as well as a conditional use permit in accordance with this decision in order. On the screen now, you all have a copy of it in front of you, so you can see the rationale that was used at that time. So in accordance with the city code, the decision regarding the variances to separation were forwarded to city council for their review. So that took place on November 19th. So on November 19th, the city council took action to send it back, or to remand it to this board for reconsideration. And that roll call is, here you can see it was I believe a 7-0 vote by city council at that time to remand it back to the Board of Adjustment for further study. And then following that city council meeting, the city council mayor drafted this letter that's also in front of your seats, giving a few reasons why they feel the decision made by the board in October didn't necessarily meet the criteria necessary for granting the variances. So in this letter, the council mayor has asked that the board vote today to reconsider the approvals for those 2 variances. And again, that would, if the board does vote, that a public hearing would be held on January 23rd, and new public notices would be mailed at that time. And I don't know how much in depth you need me to go at this time, but here's just the packet of information that the board used in October when approving the use or the variances to separations. As staff, we feel that the board should we also feel the board should reopen the public hearing. As noted in the decision in order, a few of the criteria used for granting the variances, or a few of the findings this board had, we feel that they wouldn't necessarily hold up in court. One of those being the functional obsolescence of the site makes it so that a liquor store is the only use of this property. We feel that it's zone C2, which allows quite a few commercial uses. We feel that one of those could go into there and have a successful operation. We also felt that using a physical travel distance rather than the measurement from property line to property line was also flawed. And then the fact that using the rationale that Hubble Avenue is a major commercial corridor is a rationale for granting the variances we were also concerned with. So for those reasons, we've recommended that the board reopen the public hearing in January. So.
Bert, do you recommend that the applicant be able to speak today? It's kind of ambiguous whether this is a public hearing.
It's not really a public hearing today. It's just discussion. I feel if the board would like to ask questions, I don't know that we would oppose that.
You have some evidence there from the hearing.
Sure.
I have a couple of questions about it, but the first, I think, is a procedural one. Our vote was 6-0. To send it to a new meeting, does the person that was absent from that meeting get to vote? That's the first question I have. Second question is, do you have the consent map from last time?
Yes. We had 4 cards that came back.
What's the brown mean?
That's actually green. That was-
I see. Okay, there you are. Okay, so the church didn't object, and no daycare center objected. Is that right?
Correct.
Okay. Do you have an answer to the question about
The member that wasn't here?
the member that wasn't here? Does that member get to vote
Well, it calls for a rehearing.
for,
Yeah.
does he get to vote for a
You would have to
rehearing?
hear all of the evidence.
No, no.
No,
Yes.
If we vote to rehear it, does he get to vote on that?
Just the rehearing.
just the rehearing.
portion.
No.
Okay,
I would-
so we're going to use 6 votes,
Yes.
whether we're going to rehear it or not rehear it.
He hasn't heard any of the evidence.
Exactly.
Yes.
Yeah.
And is this a 4 vote or plural?
I was thinking about that, and it requires at least 4 votes.
Well, yeah, if it's 3-3, it'll make any difference.
I think it's an affirmative action.
Come on, Bill.
Okay. Are we open to discussion now on the board?
We will in a second. Can Brooke ask questions then, too? You were missing at the last meeting, weren't you?
Right.
Yeah. Can he ask questions in this discussion?
Well, I think he could.
Okay.
As a member of the board, but
Okay.
Go ahead.
I was confused on the distance when the staff, what were the staff recommendations on distance last time? Was it based on physical distance, or was it based on straight line?
It was property line to property line, straight line, so
Okay.
not the travel distance.
Also, did everybody, did anyone have a chance to look at the replay of the city council meeting where this was discussed?
Yeah, I did.
I did as well.
One of the council members spoke about his observations. Now, he wasn't at our meeting, but can we take that information that was spoken at the city council meeting, since it was a public forum?
Well, it was a public forum, but it was at a city council meeting, and the record has to be made before the board,
Before this board.
this board.
In other words, if that city councilman wanted to testify about what he had done or heard or whatever, he could have come and appeared at the time.
Originally,
Yeah.
and
Or
in
today.
January, if you so choose.
Yes.
For today.
Yeah.
Okay.
Okay, Mr. Chairman, I've got a couple of things to say about the mayor's letter, if I...
Go right ahead. I've
Now-
probably got a few myself.
Well, the whole thing here is whether or not we ought to grant a variance. And the city council seemed to be pretty adamant about the fact that when they say 500 feet from this place, they mean 500 feet. And when they say X number of feet from a daycare, they mean X number of feet. And they say, the staff has indicated, well, you know, there are other uses for this property. And that's a fair, that's what your understanding of the staff's position is too.
Correct.
All right. On the city assessor's website, this property was assessed in 2009 at $302,000. This property sold by a national corporation to the applicant for $42,500. Now, if a drop of 80% of value isn't an indication of functional obsolescence, and perhaps nothing else ought to be there, you know. Right now, the way the property is, he's going to close the property if he can't get some relief. You can't, most of these little gas stations open as bars, but that would be prohibited under our laws. And you keep saying there's other uses. Perhaps the staff would outline those uses.
Well, it doesn't necessarily have to use this existing building. The building could be torn down and a new building that's more functional in today's market.
The city assessor assessed the land at $99,500, but the applicant paid $42,500 for the land and the building. Now, do you suppose that we're getting close to a negative value for this piece of property because you have to pay to tear the building down? In other words, I guess what I'm saying is that at what point does the staff consider functional obsolescence? Half of value? 80% of value? I mean, what's the drop have to be? I mean, you can always plow it up and plant vegetables on it.
Yeah, well, we feel that if a liquor store can work there, and the liquor store is selling stuff, why couldn't a retail store where they're selling stuff? We don't feel that it necessarily has to be selling hard liquor. Maybe it had more value when it was a gas station.
When a
and
corporation
gas
goes to
station
sell a
is no
property,
longer-
you know, they put it on the market. This is the only one that came forward. The only one that's willing to take a chance on the property. I don't know that, but I do know that he appealed the taxes then. And you know that the Board of Adjustment cut the taxes from $287,000 assessed value to $200,000. Where's his release? Well, that's all I.
Go ahead, Mel.
Bert, if this use was to close, and as you said, maybe some other business can come in there, let's say a donut shop or something. If the business closes and another use comes in, would that automatically trigger new requirements for site plan, open space, parking, landscaping, et cetera?
Yeah, if it was a change in use, it would
Okay.
require a site plan, which
Okay,
and there is a fairly large space in front of the building, like under where the canopy is now.
right,
They would only have to have a 5-foot front yard setback, paving setback along Hubble, so.
okay,
And it's a small enough building that it would probably only require 3 or 4 off-street parking spaces
okay.
for
All
retail,
right.
so.
But the idea is, you know, if the other use wanted to come in, they'd have to go through some additional procedures. They can't just change the sign and open a new business tomorrow. They'd have to go jump through more hoops
Yeah.
to do this, which I think, you know, going to Tom's point, again, goes back to then how saleable is this? I would rather have a use in a business, in a building, as long as that use is not causing any detrimental harm. I haven't heard anything about shootings on the property. I haven't heard about people urinating on the property. I haven't heard of people getting shot in the head on the property. And we know where we've heard about those things. And we know that's probably one of the main reasons that the city passed the ordinance that they did. I'm not here to be an advocate for more liquor stores, but I'm not here to close businesses and generate more what I call in my industry brownfields. This is a former gas station. Lots of banks don't lend on former gas stations, whether the tanks are out of the ground or not. I'd rather have somebody occupying the property, keeping the windows from being broke, keeping a door open here. And from everything I can tell, we don't have any excessive police reports or any problems here. It's our job as this board. There's ordinance for everything that we see here. Even if you want to build a garage too close to the property line, that's a city law or an ordinance just as much as this is. And while the city council clearly told us, well, we passed this ordinance for you to enforce it. Well, we give variances on many other ordinances every day. It's our job to put it into the context of what's reasonable, what's equitable, and certainly we don't want to have an adverse impact on the neighborhood. I think we'd have a worse impact on this neighborhood if we've got another vacant property sitting here. We got Dulles 250 feet away. Nobody's redeveloped that, and that's a big C2 parcel. Where's the Marshalls? Where's the movie theater? Where's the retail? It's not in our city. Now, maybe if we didn't have a bunch of liquor stores, does that mean that we would have more retail? I don't know if I can equate the two. I'm not advancing more liquor stores in this city, but I don't want to see a business close that, from what I can tell, has been doing or trying to do what he's supposed to. Now, that's as much advocacy as I'm going to give for the guy, but I also don't feel like throwing him under the bus here.
And Sue just asked me to clarify that if it would be used for retail use, that would be considered a similar use to the liquor
okay.
store now, so they wouldn't have to,
Okay.
they'd have
All right.
grandfather rights for a retail use.
Well, good for him, that's good. Unless now, what if there was no use for a period of 6 or 12 months? Then that's
it'd be a
different.
different story.
Okay. Which is probably still the situation we would have, that it would sit here for lease, for rent, and it would probably be pretty tough. Then we'd have somebody right in front of us asking for relief on something else.
Brooke?
To follow up on Mel, I think he's hit on an interesting point that I've thought about, is the contrary to the public interest. The public interest, I think, is served to collect tax dollars on a piece of property and on an operating business versus it sitting vacant. So to me, the letter from the council is contradictory in that respect. They want us to act in the public interest, but if we let it sit vacant for the next 3 years and there's no business there, is that in the public interest? If it sits vacant for the next 3 years and the person can't sell it, is that a liable issue back to the council? If the council doesn't want liquor stores, then they should say so, period.
I'm sharing the frustration level everybody else is feeling on this. I watched the replay, and I've read the letter, and it's almost like they're drawing a line, that this is something that they're taking extremely seriously. This probably comes from residents beating on their door, and that's where it came, and that's why we're faced with this ordinance. We're here today just to vote on a chance to rehear it. I'm in favor of rehearing it, and I would like to have, if we can, one of the council members come here and talk at that hearing. So the thing I wanted to get to is when I talked to Mike, he said, I can listen to what they say in the council meeting, but it's not part of our decision-making process. I think we all need to have that as part of decision-making process. We're putting the questions back and forth between us as we observe this whole thing, but I think we need to share it with at least one member of the council that could step up and help us out and at least give us some guidance on this, because if you look at the way that the ordinance is written, as Mike has pointed out, state law allows us to give them a variance. If they're saying, no, we want these distance rules upheld, we want these functions upheld, this is what we intended for the ordinance, and I want to hear it from them, so it is part of the record. So I'm looking for a motion. I'd like to rehear this at the, Bert, what meeting? Bert?
January
Yeah, January
23rd.
23rd? 23rd? January 23rd? Yeah.
Mr. Chairman, much as I too am a person that likes to see things peaceably resolved, I don't see the point. That is, what new could be added? I saw the city council meeting. I saw a city councilman say, I'd gotten a couple of phone calls about this. I don't care.
Well, the same councilman made the comment that he observed some activity that no one else talked about.
I'll go with that.
He didn't write a letter.
No.
He didn't outline it to anybody. He didn't do anything.
And Mr. Chair, I think that council person mentioned seeing young people leave with brown bags. And the councilman went on to say, I don't know what was in those bags, if I recall correctly, but it looks suspicious. That's not evidence to me. That's not a report of selling to minors. If he was selling to minors and got caught, we'd have a police report, he'd have a big fine, we'd have plenty of reason to deny a license. And I think the intent from the council, what they intended, what they meant, they sent us a letter. They put it clearly in there. They had great legal advice from the city attorney on the intent of their letter. I don't know what more I would want to hear. I think maybe a message back is we don't take this lightly. And I know that most of you can count on your fingers who we've approved and also who we've denied. We have denied a number of liquor licenses, well, not licenses, but a number of variances, exceptions, conditional use things here for some of these because they did present that nuisance. They were going to be detrimental to the neighborhood. We have not just carte blanche decided phooey on the city council. I understand what their intent was. I do that for everything we have here, not just liquor stores. You know, and we've said no to a number, and I'm sure we will again. But I want to look at them case by case, look at setbacks, distances, the character of the neighborhood, what people say. That's the mission we have here. That's why we have hearings for this.
And by the way, just so that the members here are clear, if we deny a rehearing, that's not the end of the road. Any citizen can appeal this to district court. Doesn't take the city council to do it. Any citizen can do it.
While I listened to all
An
this
attorney
good
advertised.
sage advice, I still think we need to open it up and hear it one more time. It's not the first time we've done it before. We've listened to people bring decisions back and vote on them again. I think we owe the city council at least that much, so that they can at least explain to their constituents, yes, we're listening, we told them to listen to it again, and they're going to listen to it again. That's my view. So,
Do we have anyone here from the public today that would like to speak to that? And if so, can we do that?
I don't, the public hearing hasn't been noticed. It would be an illegal hearing.
Okay, okay.
I would like to see us open it up and have a rehearing. I think this corridor is too important of a corridor to not reopen.
Jake?
I think the issue is bigger than the corridor. I agree with you that the corridor is important, but I think the issue is direction from council going forward. If we've got to have a ordinance in place and our body is to look at every case by case and take in all the criteria, they don't have the time to do that at a council. That's why we're here. So we can provide a venue for them to provide that guidance. I think
That's
that's
I'd rather have that. And that way, everybody weighs in at the same time. So I'll make the motion then that we hear it at the January 23rd meeting.
Second.
Been moved and seconded. Is there any further discussion? All those in favor, raise your hand and say aye. So far, 3. Okay, all those opposed, raise your hand and say aye. Okay, motion fails 3-3. Do I hear a second motion then?
None's necessary.
So at 3-3, what do we got, Mike?
You've got a motion that failed.
So,
And the decision appears to be that you do not want a second hearing, which the consequences of that are the decision and order from the October meeting stand.
okay. So, as it is, then there's no rehearing for this. Okay.
Mr. Chair, I could not vote, but I would have voted to not rehear.
Okay. Thanks, Brooke. All right, moving on. Item 5. This was carried over from the November meeting. It's a conditional use permit and variance at 1824 Hubble.
Mr. Chair, members of the board, item number 5 is a request for a conditional use permit that would allow an existing liquor store to expand. In order to expand, they need to meet the current separation distance requirements. This liquor store originally was granted the conditional use in January of 2012, before the current separation distances were put into effect. So in order to expand, they do need to meet the current requirements, which require 500 feet of separation from any church, school, park, or daycare. There are 4 of those within 500 feet, one of those being the St. Peter's Church. And then we have Ashfield Park, and then we have 2 in-home daycares within 500 feet to the south. So they need variance to the 500-foot separation requirement. The subject property is on the north side of Hubble Avenue. It's the SQ Liquor site. and I know I went over all of this last month, so I won't go too in-depth, but I'm just putting up the site sketch that shows where they would be expanding the liquor store. They would be putting 2 additions on, one on the east side of the building, one on the south side. It would basically double the size of the liquor store. The applicant indicates their intent for the expansion would be to allow them to expand their selection of merchandise available for sale. However, one of the reasons it was continued from last month was so the applicant could clarify. If you remember, just the contractor was here last month, not the business operator. But it was continued so the business operator could both be here and to clarify whether they intend to meet the 60-40 rule. They have since said that yes, more than 40% of their sales would continue to come from liquor or alcohol and tobacco products, even with the expanded selection. So, or the site photos and the police reports are in front of your seats again. The consent map, this is same as last month. We had 3 cards come back in support, and then the applicant submitted a petition signed by many people in the area, including a few within the 250-foot notification area. Staff doesn't believe that they've satisfied the criteria necessary for granting a variance. As you recall, the criteria for granting a variance include that there would be no reasonable use of the property if the variance was not granted, and also that the proposed use would not be within character of the neighborhood. We feel that since this is zoned C2, again, there's a whole list of uses that would be allowed on the property. And they could also continue to operate as a liquor store. They'd just be confined to their current footprint in accordance with their current conditional use permit. And we also are concerned that expanding the liquor store that's within such close proximity to so many houses, the church and the park and these daycares, that's not in harmony with the character of the neighborhood. So for those reasons, we've recommended denial of the variance. And I also forgot to mention, they also need a variance to the front yard setback along Hubble Avenue. They would be within 9 feet of the front property line. Zone C2, which requires a 25-foot setback. So we don't feel that a 9-foot setback meets the test for a variance either. So with the recommendation for the denial of the variance of the separation and the variance of the setback, I guess it goes hand in hand that we also recommend denial of the conditional use permit. So any questions?
Yeah, Brooke?
When you said the distance, again, Bert, that's property line to property line?
Property line to property line.
Are any of the, on the consent map that are in green, any of those facilities?
No. The church is the St. Peter's Catholic Church right here, and then the park, it's city-owned. The city doesn't typically send cards back, and then I believe one of the daycares is here, and then the other was on along Capitol Avenue, and they were not notified.
So none of those establishments sent any cards back?
Correct.
For or against?
Correct.
Any other questions?
Yeah, is this our first one that wants an expansion to be a liquor store?
It's the first one I can recall.
So what's before us is whether or not he's going to expand or not.
Right.
All right.
Yeah, he can continue operating his current liquor store. He just has to be confined to the current building.
And Bert, as a quote current liquor store, could he sell up to 100%
Yes.
liquor with no problem?
Correct.
Okay.
So he's already a liquor store.
Yeah.
Okay. All right. There's no 40-60 split in this
No.
case or anything. Okay.
Do we know how long they've been in
Uh,
business there?
Their conditional use permit was issued last January of 2012, of this year, so.
And this, if I recall, this had been a pizza delivery,
I think,
pizza to go
yeah.
thing at one time.
Yeah, years ago, it was a Pizza Hut to go, and then
Okay.
it was a convenience store. It was supposed to meet the 50-50 sales
Right.
at that time. They weren't meeting that, so they applied for the conditional use permit to be a liquor store. They were granted that.
And I know this might go way far back in time, you may not know this, but before it was the pizza delivery thing, was it a converted use or a house? It's kind of a unique building.
I don't know.
Any idea? Okay.
Any other questions?
Yeah, I can't remember.
Thanks, Bert. Applicant or representative of the applicant?
Hi, my name is Inder Dillon, 8210 Dennis Drive, Urbandale, and I operate the business at 1824 Hubble. And I know there was some confusions last week what I intend to do with the business, so I'm kind of here to clarify all that up. Pretty much what I'm asking for is an expansion at the current store to add more C-store items, convenience store items. That's what I'm asking the expansion for. And you got your items from, your groceries, to your dry goods, to your snacks, candies, all that. That's what the expansion is I'm asking for. I'm currently hold a liquor license, which was renewed this Monday. And I also hold the conditional use permit that was given to me in January, like Bert stated. Pretty much what the reason I became a liquor store was before, when I opened it in 2009, I was a convenience store. But the new 60/40, I was meeting the 50/50, but when the 60/40 was I was not going to meet the 40%, which also included tobacco in this. So I was had to come up in front of this board to ask you for the conditional use, which I got. A couple of reasons I'm requesting this expansion is, first, I don't have much room at that place to do anything I want. I've worked with Terry to rearrange how I'm going to do this. The location's only about 1,300 square feet. In that amount of space, I can't really do what I want. Second main thing is the customer base that I get is mainly foot traffic that come through there, and they want me to put more convenience store items in there so they don't have to go down to Quick Trip on East 14th or that Hispanic store on Des Moines Street, which is about 4 or 5 blocks, but some of these people don't have transportation to go there. So that is another reason that I'm doing it, the main reason. I have a small shelf in there for grocery items, but it's not enough to they still have to go down to Quick Trip or they have to go to the Hispanic store. You guys have gotten some consent forms, consent cards back from them, which is they are in support. I have gotten a petition signed by the neighbors that show support for it, and I've tried getting a hold of Peggy Hill, the Capitol Hill East Neighborhood Association, and she has not replied back to anything. So, somewhere. Oh.
I didn't mean to interrupt.
I believe there's a question last week about the new addition of the cooler that I'm putting in. On that one, I'm not bringing in any more alcoholic products or anything. I'm gonna want to show you the cooler that I have right now at the west end of that building. I couldn't take a. Okay, so we have to go in pieces here to see it, because I couldn't take a picture of it from right in front of the cooler because there's no space. I can't do it. There's a 7-door walk-in cooler right here. 3 doors are for alcohol. And this is the same cooler right here. And 4 doors that are right there is for your energy drinks, pop, soda, and all that. And the walk-in portion is where I have it also divided up according to the 3 cooler door space, is where your 24 packs of beer, 18 packs of beer, that's what's in there. And the other 4 door space that's in the back in the walk-in cooler is where you got your 4 packs of Red Bull, your 6 packs of Pops, and all that. Right now, that cooler is so crowded that customers have to go in to get everything. If they can't find it right there in front of the coolers, they have to go in to get it. Which, I mean, it's so crowded. That's the reason I'm requesting the new cooler addition. So what I'm planning on doing with this new cooler is moving all the alcohol into the new cooler and keeping the old cooler just for non-alcoholic drinks. So the back would be used for nothing but storage. And that's the reason. And also with this cooler, I'm putting in a 3-door freezer, which is going to hold your ice creams and all that, and 1 cooler is going to be set for your milk, your eggs and all that. And I know the thing comes up, I am a liquor store. If you grant me this conditional use permit, what is stopping me from kind of, hey, you know what, 1 week I do what I tell you I'm doing today, and the next week I was like, you know what, it's not working out, let's take it out, put it in the liquor store. One thing I can propose is in the conditional use permit as a condition they're set, can we maybe put some sort of a condition down that says, hey, the new addition will only have non-alcoholic products and non-tobacco products? And you guys can enforce it any way you want. I know the city, when the renewal is done, the city comes in every year and they check it out, see if it's up to date and everything. And you guys can check it out, you know, once a year, twice a year, or 3 times a year, however you guys like. That's kind of like the only guarantee I can give you. Other than that, you know, hey, I'll be held responsible. I'll lose my entire conditional use permit if I don't do what I'm telling you guys I'm going to do today.
Brooke?
So the new space and the new facilities, coolers, you're not going to stock any more alcoholic?
No, I think it has enough alcohol as it is.
Yeah.
And
So it's all for non-alcohol and
Yep.
non-tobacco products?
Yep. And that's kind of one of those things, I know as a liquor store, you guys got to grant me the conditional use. The only thing I could come up with is I'm not going to meet the 40% of what is stated. I'm still going to be driving more of my revenue above that 40% from alcohol and tobacco, but the new addition I will only use as convenience store products, and you guys can put down a condition in there that, hey, if an inspector comes at the end of the year and sees, hey, in the new addition, there's alcohol, you know, you can bring it back here and just revoke it.
Mel?
One of the variances you've requested is the setback requirements from Hubble. It's normally 25 feet of front yard setback, you know, green space back from the road. You're asking to have relief so that you're within almost 9 feet of the right-of-way. And I'm, hang on a second. I'm curious, if you're going to be a little bit more closer to the road here and you've got the little sketches there, do you have like a profile drawing or any kind of a description of what the new construction would look like?
Actually, yes, they do have it. The city does have that. They actually showed it the other day. I don't have a small version with me. But we are not getting any closer to Hubble Avenue. That 9-foot setback stays in line with the building.
I realize the
That's
little
where
peak is
existing
out there,
building is now.
but there were probably some variations or variances granted for that at the time.
If you'll look on this corner here, that's why we've cut that corner off and made
Okay.
this about a 30-degree angle right there,
Right.
is to stay the same distance that the building is now from Hubble. So we don't encroach any closer to Hubble than the building already is.
And you're going to enclose the porch or awning there on what I want to call the east side,
We
correct?
will not extend past the existing roof
Okay,
that's
all
already
right.
there.
So
Yes.
do you have like a profile or elevation, am I using the right term, Jake? That shows what the facade's going to look like? How is this going to look once it's built?
I do not have one with me. What the outside of that building will look like is it's going to have vinyl siding on the outside to match the existing part of the rest of the building. This side over here will be mainly windows and entry doors.
Okay.
This here will be also closed inside.
Okay.
Any other questions for the applicant? Thank you. Is there anybody else here to speak in support? Is there anybody here to speak in opposition? Any last questions for staff?
Yes. Will this trigger a new site plan?
Yes.
Landscaping requirements, do we have any gravel parking or how's that paving in there?
Chair, members of the board, Sue Ann Donovan, Zoning Enforcement Officer. For the record, staff is opposed to the expansion, especially in light of the variances for distance and separation. Additionally, he already has a business that's in operation, is viable. There's not going to be loss of income or no other use of this property if he doesn't get the expansion. We're in opposition to the variance for those reasons. Yes, he would have to bring the site into compliance with current site plan regulations.
Was that discussed with him, to your knowledge? Okay.
Yes, he was
Okay.
made aware of that at the
Okay.
pre-application meeting.
All right, thank you.
Just a question. If his goal is to try and become a convenience store again?
No.
Getting this expansion, I know. But has anybody ever given up their liquor license and gone back to a convenience store, to your knowledge?
No.
Okay.
And I don't think that's what his intent is. His intent is to keep the liquor license and expand his floor area. Now, as far as the enforcement portion of it, he can say to you, we'll make sure that when we get inspected prior to our liquor license that we don't have alcohol in that portion, but we're not going to be going in there every day to make sure how he's stocking the shelves. I think that's an undue burden on the enforcement to make us have to do that in order to make sure he's in compliance. I see no reason for him to be granted a variance to expand a liquor store.
Any other questions? Thanks, Sue Ann. Close the public portion and go to board decision.
And didn't you want to ask if there's anybody against this?
Did he?
I did.
Oh, did you?
Yeah.
Yeah, I
That's why we had staff come up.
It wasn't just my question about the site plan.
So we're on board decision now, folks.
Well, I think this is different than the previous one. And the difference is it's a viable business. It hasn't lost 80% of its value. You know, he's running a liquor store. He wants us to allow him to expand a liquor store, and it's a tough site. I agree with him. It's a tough site.
Mm-hmm.
If it was the idea that we use these artificial numbers from this place or that place or the other place to prevent somebody from expanding and being in competition with other people, you know, is, in my mind, not exactly a libertarian view of what we ought to be doing. But he clearly doesn't meet the criteria for granting a variance that I've seen, I mean, that he's proposed to us, whereas the previous one did.
Mm-hmm. Other thoughts?
I would agree with Tom. I would not support the expansion of a liquor store. I'm just opposed to that. If there's any area that probably could use a convenience store, this is probably it. But if he said, I want to do away with my liquor license and make it a convenience store, I would support the expansion. But I can't support the expansion when I know it's a liquor store and I know he can be gone tomorrow and the next guy could come in there and it's still okay to be a liquor store. We do not need any more liquor stores in our neighborhoods. So I would have to move staff recommendations.
Okay.
I'll second.
Been moved and second. Is there any further discussion? Motion is to. Yep.
If we could only do a variance, I mean, we can't do a exception, and it would only be as long as this gentleman owned the place?
That would be up to, as a friendly amendment to the person who made the motion.
I don't know that that's available, is it?
Well, yeah.
I don't think it affects the separation requirements. It might be talking about setback, I think you are, but that in itself wouldn't be enough to grant him relief.
So we can't do that?
Right.
Right. I mean, I would take the gentleman at his word. I find that somewhat interesting that we would not take somebody at his word. As having been a part of 4 generations and family businesses in Des Moines for over 100 years, that somewhat offends me. And I think I think the guy's come up and, in all honesty, told us what he was going to do and how he was going to do it. And I think he was very truthful.
Okay.
Can I ask a clarifying question?
Yep.
Tom made a point, I think if I heard it correctly, that he literally could take anything resembling food off the shelves and make it all liquor, correct?
Mm-hmm. And what Sue Ann's saying is it's an enforcement issue because, you know, trying to send someone down there once a week, every other week.
I get that part. I'm saying today, based on.
He could
his
still do
current-
it today.
In his
Sure.
space today,
Yeah.
he could technically expand a
He
liquor.
doesn't have to sell any food
Right,
now.
that was the question. Thanks.
Okay.
What we would hope it would do is, once convenience store, take some of that liquor away and bring in some bread and milk for the neighborhood. That's what I'd like to see.
Got something else, Mel?
When this was originally built, I would gather, since we're a little close with the kind of the point of the building to the right-of-way, there were probably some variances that had to be granted initially. From the perspective of further variance granting to get closer to the right-of-way, I'm not really in favor of that. If it can work the way it works now, fine. But this is near the intersection of Hubble and Grand. I'd like to keep the right-of-way open space and green space we have there. He has some landscape around it now with trees. Doesn't look too bad. I'm not interested in encroaching further into our right-of-way with additional variances for that. And, if he's doing well now, I think he can continue to do that as it sits.
Okay. Any other comments? There's a motion on, to take the staff recommendation to deny. All those in favor, raise your hand, say aye. Those opposed? Motion carries 5-2. Item 6 was carried over from the November meeting as well. It's an exception at 121 Zwart Road, and I think you've got some information about the plating.
Yes, and I'll hand around the previous comments. Brooke wasn't here, so. If you recall, there was some discussion about trees as well. I believe that the applicant's going to be prepared to speak to other findings that they've gotten recently on the soil testing, but staff still maintains the same staff recommendation. It was platted in '82, replatted, and there was relief granted based on another address, but for the collective set of lots along there to create 4, and I will pass that around for you, that previous decision in order of the board, so you can see their rationale in deciding that this should be a buildable lot, basically. And the way that we determined that is when they executed the plat instrument to create all these lots, that was the exercising of the relief. So the fact that this lot wasn't built doesn't mean the relief expired. So you'll notice we dropped the 2 appeals for the lot area and the lot width off of the agenda. So those really aren't under consideration anymore. We've determined that the previous relief is in place to allow that lot to be created, basically, and make it a buildable lot. So the question now is whether we should allow the setback relief on the side yard setbacks, the front yard setback along Zwart, and the single-family design guidelines. They may not be going with an absolutely flat roof, but the belief is that their design will not meet the 312 pitch requirement that's in the single-family design guidelines. So they would still need that relief to do the project that they're proposing. Staff, they're all exceptions. The relief for the single-family design guideline is a little different than the other exceptions. That relief is based on a unique design, views, and vegetation. So when you're considering the roof component, you look at, is there unique views, terrain, and vegetation in this property? And I would say yes, if you look at it. And then the second is, it's unique in its design, and it certainly is, they're looking at an architecturally designed home, so it's not something that's modular or run-of-the-mill or regular in nature, I should say. And looking at the side yards, staff looked and said, is there a practical difficulty? And one of the things, there's I should put an exhibit on that, sorry. I'm gonna call that Exhibit A. This is the board's previous finding to allow that lot to be created. And then this is the survey that indicated the trees. Now, I don't know if you can see on your monitor, not all of these trees would actually be subject to the recommended condition about tree mitigation. The ones that are 12 inches or larger are highlighted in yellow. And so you can see there's a few that are less than that, that if they were removed, we wouldn't require them to mitigate. It also kind of shows you then what area of the property they have to work with in bringing this out over the hill. It's, you know, they would be at grade basically towards the street, and then it would cantilever out as you went to the south. And by bringing it closer to Zwart Road, the lot lines narrow the width, so the ability to meet the side yard is more difficult with a standard size footprint. So, and again, I think they previously indicated that this isn't going to be a, you know, some small footprint. It's going to be a reasonably valued home for the area and substantially valued. So their concern is, given the soils, they may have to shift within that 10 foot on one side or the other to get it to fit and to avoid possibly removing a tree. So they want that flexibility to be able to design that in. I think they indicated their intent was to try to maximize whatever those side yard setbacks could be, given adjustments they would have to make. And staff again believes there's this practical difficulty there due to the way the land currently exists. So then the question comes, is it in character? So it really comes down to, do you believe a house that's built a little closer to Zwart Road, a little closer to each of the neighbors possibly, probably not built closer to both, but, and then also by bringing it north, are they preserving then these other views that are more a priority? I don't think the views to Zwart Road are necessarily as important as views to the south toward the river valley where the timbered areas are. So they're actually, by moving it towards Zwart, preserving some of those view sheds for the neighbors and preserving that character. So staff recommends the same as previous, which is approval. I think I'll let the appellant go over what they found with their information, and they may be able to make some adjustments based on information they know about their soils information. And I do believe they've also met with representatives of one of the neighbors who I think is also representing more than just the one, but also one of the other ones. So
That's what we wanted to have happen.
Could we see the consent map?
yeah, the consent, we didn't get any more written objections, so you had some verbal objections.
You didn't re-notify.
Well, you just passed
No,
a
no, no.
card around that was a written objection.
Right, and that was the same as previous.
Okay.
And I do have photos if you want to see that too. I just had that consent map.
Mr. Chair, I'll be recusing myself just as I did the last time.
So,
I'll be recusing myself as I did the last
oh,
time.
that's right. Thanks, Jake.
Shows the property owner just to the east. Marked in red, so, no, I just had that. Here we go. So if the subject property is hatched, the card came from the property owner to the east, which spoke at the last hearing, who spoke at the last hearing.
And I've got one more question. When they bought this lot, they knew it was a difficult build on it. Is their position today that they can't build any house on there without this?
I don't know if that's their
They want
position.
to
I think
build a
it's
special house.
Right, and that isn't the test, though. That's not a hardship test, it's a practical difficulty, so that the house they're seeking to build is challenged by the nature of the property, so.
That may well be, but the neighbors on each side have already built their houses. And now they wish to crowd the lot line on one side or the other. Isn't that the case?
Yes,
Okay. Because it is a 10-foot set from each side, right?
yes,
And they want to reduce it to a flexible 10 feet, so it's a combination 5 plus 5, 8 plus 2?
The maximum would be 5 and 5, yeah. That would be the and 10 of the total. Yes.
But it could be 8 and 2. Could be 9 and 1.
No.
The way it's drafted here.
Well, the way they would not go any closer than 5 on either side yard, the way they're requesting. So the requirement is 10 on each side yard.
Yes.
They're asking for half of that on either side, which is down to 5, which keeps it in the exception level of appeal. If you went less than 5, it would actually be a variance.
So they're not asking for a floating 10-foot side yard setback?
No, they're asking for the absolute to go to 5 and 5. They believe they can design, so maybe it's even better than that, but
All right.
they're not asking for anything closer than 5, no.
They wouldn't be just expanding the house 5 foot on this side and 5 foot on this side in order to use up the space. But they could.
Yeah, under this relief, they could, yes.
Okay.
Any other questions for staff? Thanks, Eric. Applicant or representative of the applicant?
Thanks, Eric. Hello. Thanks for your time today, and thanks for allowing us the opportunity to come on back and explain these exceptions in our proposal to the
Matt?
board. My name's
For the record.
Matt Connolly, 3105 34th Place, Beaverdale. So we'll show you here in a second, but just from what Mr. Clark said here, we're going for 7.5 on each side, basically. We're going to stay with asking for 5 on each side, but really we've designed it so far if we are able to proceed at 7.5. And we'll be able to address all these exceptions and a few reasons why for each. But first I want to say that this is an infill lot development issue. As far, in my mind, I feel that the resistance here is coming from the neighbors, which rightfully so, because we're going to obstruct a view out their side of their houses. We're going to very much not obstruct their view to the southwest and the southeast sides and the south. They're just not going to be able to look straight out their side of their house at an empty lot anymore. And that's what their honest belief, or that's what their struggle is. They've been looking at this beautiful lot this whole time, and I'm with them. It is a beautiful lot, and they have had a great opportunity to enjoy this empty lot next door this whole time. So with that being said, that's not a good enough reason for us not to build on this lot, though. The other thing is that if it is a safety issue at all, then we're here to address that part of it. If they have an issue with the safety of their property and ours, then we're definitely here to address that part of it. We are. This is a green project, according to the City of Des Moines website. Green projects, according to the mayor and city staff, and the city consensus in general is to help promote green projects as such for more sustainable development in the city of Des Moines. And I'd ask to keep that in mind as far as moving forward that way. I want to back that up by saying, we're all aware of the Tomorrow Plan, the Capitol Crossroads project, and the DART makeover, and all those big projects for the city of Des Moines and have all concluded that City of Des Moines has awesome opportunity for urban sprawl. And that is very much what we are doing here in a very sustainable growth pattern for the City of Des Moines. Okay, so we're going to bring the architect up here and show you. I'll put on the overhead how, one, the sight lines will be greatly reduced at the best possible scenario here for the neighbors. Just so happens to be the best scenario for us too, but this will reduce the sight lines at the greatest level by the relief that we're asking for. I mentioned that we're on the 7.5-foot path, which is, we were asking for 5-foot side yards. Really, we're still asking for 5-foot side yards, but we're going to go with, we're really going to proposing 7.5-foot side yards now. The soil, which I'll let Zane, the architect here, report on what we found on the soil, but you guys asked us to go figure out what we want to do for a footprint, and that's what we're providing, and then also what we found about the soil. And so we've put forth thousands of dollars to go find out a soil report from some very reputable and expert engineers here in town. And with that said, we have found with our professional building expertise and design expertise that we are wanting to move forward with this build to order on this property. That's not to say that we will indeed build on this property because stuff falls through. We do plan on closing on this lot and making it our own for real soon here. If granted this relief anyway. So we did meet with the neighbors yesterday and their attorney, and we all talked it out. They're privy to all this information that you guys are going to see now. One day earlier, we had a nice meeting. Bottom line is, if they don't want to allow us the relief, then we have no choice but to still consider purchasing the lot, which is a great possibility. There's a lot of people that can build on the footprint that would be allowed by the city parameters. But, with that being said, there's a lot of opportunity here still within the parameters. And we'll show you what the parameters allow right now on site restrictions and whatnot as well. I've talked a lot about that. I'm gonna leave time at the end, if that's all right, for...
You got about 1 minute, man.
1 minute left. Zane.
Yeah, smart move.
Yeah. Sorry, I forget we're on a time crunch.
Zane Muntz, 7811 Maryland Drive in Windsor Heights.
Yeah.
And is it okay if I point over here?
That helped us a lot, yes.
Okay. So this is the, do you have?
Is this current?
Okay, so I'll start with you. So this is the current buildable footprint that is out there. So there was a question asked earlier about the lot lines. This is showing the 10-foot setbacks and the 30 at the front and the 30 at the back. So that's what we could build on to date, no issues, and we'd be going down the road. And as you can tell, it's essentially what the neighbors to the east and the west have done. They've sort of built halfway up at the hill right in the center. What we're proposing is to move the front a little bit closer, and staff did a great job of representing this. I'm kind of re-articulating some of those. And then, like Matt was introduced, once we did some more planning, and just to bring you up to date from where we last were, we're now into design development. So we've taken the house further in the planning process, so we can say definitively that we can stay within 47'6" is your entire front width of this home. The current buildable footprint in here would allow around 45 feet, which you start to see on the next slide. So this is essentially a 45 by 45 foot box, which fits our plan to date. and this is again on the current footprint. What we're showing though is if you take the side window out of the house to the west and the side window out the house to the east, you can see how it significantly, by building in the original footprint or the current footprint, really starts to restrict views through the site. So again, one of the things that we were doing from the very beginning was trying to understand, again, how we could move this closer to Zwart to give access from Zwart to help, relieve any of the, there's no Zwart access along the north. So this would give us great access off of Zwart, which we think is better for universal design, which is, as you age and grow into a home, you're not having to like sell it and go to some other house. You can all live on one level. So that's a big concept that we've created from the beginning with Tony. So again, by giving ourselves a little bit more room to the side, we're able to push our house even a little bit further back. And we're also looking at some gentle, some very simple moves, just cutting off this corner of the house as well to just even greatly increase the sight lines. So those sight lines are the same from the side window from A to B, or from the current to the proposed. So essentially that's the sightline issue that we've sort of tried to understand, and we've been doing that from the beginning. The other issue that we understood, there were sort of two issues, and I apologize, I know we've gone over.
Yeah, about a minute on your side too, so.
Okay. So the second part of the issue that we understood was in terms of structural integrity of the site. I mean, that's one thing that's been in question from the beginning in terms of how we're doing this. So Tony obviously has done a great job in allowing us the resources to go and do some structural borings, which we did. We did 4 structural borings. They were over 20 foot deep. So previous studies that we've looked at showed 4 to 6 foot deep borings, which really don't tell you a whole lot. So we were able to go a lot further and analyze those a lot more with a geotechnical engineering firm, as well as have a structural engineer, myself and Tony and Matt present. And we sort of talked about all these issues last Friday to sort of come to head, which were the best possible scenarios for the site. And what we came to was, actually, the way the site works, it's better if we are able to take it and dig into the hillside, because what we would be able to do is remove a lot of the dirt, which essentially is load. So the heavier the load up on the hill, the worse it's making it for the hill. A hill wants to be more gradual. This hill is, severely sloped from the top to the bottom. So our concept for design and structural design, geotechnical design, is to remove as much dirt from the north side of the site and to help kind of spread that over the bottom to help shore up and reduce that sort of slope towards the bottom as well. And then we're going to, instead of infilling it with more dirt, which is kind of what you would do, or crushed or a bunch of things, we're actually going to use geofoam. So it's just a lightweight material, kind of put it back in there. So that way our foundation wall would actually just be a typical foundation wall. It wouldn't be this huge reinforced sort of wall. What we would have to do is go deeper down than a traditional foundation. So we'd have to do an additional 4 feet down on the north side to build a foundation. But that seemed to be, from a geotechnical, structural engineer, and architectural solution, allowed us to solve many of those issues. And that doesn't just help Tony. The idea is to reduce all that weight at the top to help the load on all of the sort of neighboring sites. So we felt that those were the 2 issues that we were sort of working with from the clients, from the opposition of the site or the setbacks. And we felt like we were addressing those with due diligence throughout. So.
Okay. Go ahead, Brooke.
When you mentioned the current footprint, that's what you're referring to, is you could build within that footprint and you wouldn't be before us. Is that correct?
That's correct.
All right.
Any other questions, Mel?
The proposal you've got with the 7.5 foot side yards, could you put that back up there quick?
Yes, sir.
With what you've got there, while you've also got outlined what you're allowed to build, like coming to the back toward Terrace Road, parallel to Terrace Road, what's the closest you would be to Terrace Road under this scenario while keeping those view sheds? Would it be, you'd still be 40 feet away, or do you got like a rough idea?
This corner here?
Yeah,
Where you're sort of,
yeah, or maybe the corner in the middle.
Closest corner, and just going off of that is 7'6". I would say we're at 40 plus, maybe 42.
Okay, so let's say 40, or you're no closer than 40 feet from Terrace. Okay, all right. Thank you.
Any other questions? Thank you.
Thank you.
Anybody else here to speak in support? Is there anybody here to speak in opposition?
Chair Gray and board members, my name is Bill Bartine, 2000 Financial Center, Des Moines, Iowa. I'm here representing David and Linda Hoppert. Their address is 128 Terrace Road. They are the neighbors to the east of the subject site. And Joe and Julie Yankee, they live to the west, and their address is 115 Zwart Road. I think this was the perfect summary of our position, is we wouldn't be here if they were dropping a normal size house into an area that was within the buildable footprint right now. But as you can see, they're building what looks like, at least they're reserving a space for a lot bigger house than has been built on either side of it. And when we get a request for an exception like this, as I told our people, you'd have to probably bear this if they were bringing a normal size footprint to us. But they say, Bill, we don't want to reduce our side setbacks because that's the way this place works for us. It's got a woodland feel to it. But there's some other issues that we had a really nice. These young men are talented. They're good people. We like working with them, and they were very forthright with us. What we had hoped, though, when we met yesterday, is we would have a copy of that soil report. Alan Derbutsky was out there last week, I think, David, doing borings, and they did what we asked them to. They got the borings, but we don't have the report. And the report, I think, would disclose a lot of interesting things that we can raise under your standards for safety and welfare effects of this property. Because I've talked to Doug Wells, who's a friend of mine, sometimes client, and well-known architect in town. He's designed a house for this property. And he was working with Alan Derbutsky. He tells me that his plan involved dropping 4 24-inch concrete piers 40 feet into the ground to anchor the site. This is going to be kind of a typical bathtub basement design, which we're real worried is going to slide down the hill. Because there's what I call the skid pan effect here, which is, we've been told by Doug, we've been told by others, it's neighborhood lore that there's a layer of shale, sometimes it's described as a layer of clay, that's just there to bounce something. It's not stable. And we're concerned about that. We're also concerned about, the aesthetics of the view. We'd have to live with that view if they'd come at us with a regular sized, form-fitting property, but that's not what we're hearing right now. The other things that we want to point out is neighborhood lore also indicates that there was a cave-in on Zwart Road roughly at the top of these properties sometime many years ago. The people who remembered this have now passed away, but there were apparently steel supports that had to be driven in to support the improvements to Zwart Road at that time. And otherwise, it is a certain amount of aesthetics, but they were there, they built the house, accepting the fact that they would have 20 feet of setback on both sides of the lot that'd be next to them, 10 on either side. And I'm sorry, did I say that? I think it was 10. They're proposing to reduce it to 5 or 7.5. I was correct. But now we get something different, and when it comes in an exception like this, we've got the ability to tell you the rest of the story is that we're concerned about some of the aspects of the danger of building on this site. I know that when David and Linda were at home while they were boring, they got to a certain point where they had to they had to drill through some rock layers, and there's some pretty good shaking that's going on in the house. They tell me that all the neighbors have houses where the floors all make pencils roll down toward the river. So we're having trouble justifying this from the safety and welfare. And buildable lot means a lot of things to different people, but in this case, there's another reason to think of it as buildable because there's some issues with it. I discussed yesterday that we'd be willing to take another deferral of this action until we could get a look at the report. I think that everybody's at this stage, in a mood to get it resolved, but in my mind, that's still out there. So with that, we would really thank the members of the board if they would give consideration to the whole picture here and not just whether a certain style of house fits on this lot. Thank you very much. Now, did anybody Dave, did you want to have any comment? Do you have any comments that you wanted to make? We have a few minutes, I trust, just to. Okay.
Yep.
Just one. I'm David Hoppert, and we live at 128 Terrace Road. I wish I had Matt's voice. That's wonderful. I don't want this to be contentious, but Zane said something about removing the dirt at the top of the hill near Zort Road so that would relieve some of the pressure on the house. The house, whatever they place on that lot, is going to slide, whether or not he relieves any pressure from behind. You can think of the simple example of standing on our driveway, or any driveway that's slanted.
We're working on it.
What are we doing?
You may not need my drawings, but.
There you go.
There we go. Okay.
Okay, that's how steep one side of our driveway is. We have a U driveway. And if you had a crane, and let's say this driveway is icy, which it sometimes gets, and so it's a slippery surface. And if a crane would drop a human being down very gently and stand that human being on that ice, and then very gently let loose, that human being is going to slide down that ice. There's no stopping it. Now, no one was pushing that person. There wasn't any force behind. The same principle exists when you have a big, heavy house sitting on a slippery surface underground. It's going to move. Every house up Zort Road has moved. Every house up Terrace Road has moved. Clear up to the governor's mansion, where Dr. Jim Kelso had the whole 1/3 of his house fall off. They're in the same kind of till soil that we're in at the end of the Iowa Glacier. And he had to have 3 engineers from Iowa State and 1 come over from England to help him design a series of 18 different steel pilings, and to the cost of, I think, $255,000, he told me, to repair it. So this is just exemplary of the entire area of very soft, loose soil. Thank you.
Thank you. I take it you're here to speak in opposition?
I'm Julie Yankee. I live at 115 Zort Road on the house on the opposite side. And I appreciate Matt's comment of this simply being about looking out at an empty lot and having that be difficult to give up. Although that is true, you know when you purchase a house and there's an empty lot next to you that's always a possibility. So we've only lived in this house 2 years, so we bought that knowing that could happen. But we also bought the house knowing we had our 10 feet. And I understand their point where they're saving the view in one direction. However, if a structure is closer to you, when you're looking out the window, the eye automatically goes to what's there. It doesn't look beyond it to see the trees that are left there because the building didn't go down. So although the empty lot would be gone, I think the fact that a house can be built in this lot within the city's requirements seems fair and reasonable to me and to, I think, anyone in this situation. What I'm saying as a neighbor is I don't want it extended because you simply want a bigger house. Our house fits in our lot without obstructing our neighbors, so I would ask the same of, and they even mentioned that another builder could build a house in those dimensions, and so I simply am in support of that, and that is all. So thank you.
Can I ask Ms. Yonke a question?
Sure. Yeah.
Ms. Yonke, I understand your concern about, what you can see that's closest to you, such as the side yard. You realize that that they could build within 30 feet then of Terrace Road, you know,
Yeah.
as you look to your south.
Yes.
If they were granted some exemptions to be a little closer to the front yard setback, would that be okay with you? If
So
the-
closer to Zwart Road?
Yes, yes.
No, that is not an issue.
That's not a big deal. It's that elbow room on the side yard you're most
Correct,
concerned about.
correct.
Okay, thank you.
Thanks.
Anybody else here to speak in opposition? Matt, you got 3 minutes to finish.
Okay, thanks for your time once again, and thanks to the neighbors, and thanks to the attorney, the fine man that we met with yesterday, and again, get to listen to today. The information that they talk about for soil engineering, the report that we've looked at previous was from 1976. We've tried up and down to try to find engineered reports, soil engineering reports, many times and through many people. We've also talked to Doug. I know Doug, he's a friend of mine as well, and Doug Wells, that is. And no one had any issue. That's why we had to go hire Alan Derbutsky. So whatever architect might have thought or builder might have thought before today doesn't really matter. The engineer's technology, skill level, and expertise of today far outlays anything from previous days. So their recommendation is for us to alleviate the lateral soil pressure coming from Zort Road into the foundation, and that's what we're proposing to do. Secondly, our footprint is very reasonable for any walkout ranch, and I'm lucky that there's not any minimal square foot requirements because we're designing a 1,410 square foot walkout ranch. So, you know, if that's too big for what they're claiming as for the neighborhood, then come on, you know. Go ahead.
Sorry, I just wanted to add one more point to that last one. In the current building configuration, where we have a 45 by 45, if you do the math, that's a 2,000 square foot home. What we have designed for closer to the footprints is actually an 1,894 square foot home. So it's actually smaller than what we need to. And the reason is because if we can get it more to the side, that allows circulation, so we don't have to create more room. I mean, it's an architectural planning sort of issue. So without getting into all that, I just wanted to mention that.
Okay. Any last questions for applicant? Any last questions for staff? Hearing none, we'll close the public portion and go to board decision. Now, Brooke is gone.
Thanks for your time.
And Jake has recused himself, so it's a 5-member vote here.
So 4 will be needed to pass any variances or exceptions, correct? Okay. Well, one thing that I don't like are tiny, tiny side yard setbacks. If you're at a 5-foot setback, I can put my arms out and I'm not tall. I could touch my house and touch the property line. Norwalk has that. I don't like that at all. It doesn't matter to me as much that this is south of Grand or this is a wooded lot. I don't like seeing encroachments next to properties. We've got owners who understand that it's a buildable lot. I'd be in support of granting the first 2 exemptions requested for the relating to the roof pitch exception and relating to the front yard setback. It sounds like the neighbors are willing to work here a little bit, but I'm a little nervous about messing with the 10-foot side yard setbacks. I know they've proposed maybe just 7.5 even. I certainly would not want to grant 5-foot side yards here. But I'd put a motion out there to grant the first 2 exceptions, the appeals for the roof pitch, an exception on the front yard setback, but I don't think I'd support the side yard setback requests. I think we can fit a good enough sized house in there. They might have to stretch it to the back a little, but it doesn't sound like that's the main concern.
Other thoughts?
I don't have any thoughts. I'll second it.
And what did you do with number 2 for the 10-foot?
He okayed
Staff
that.
recommendations.
The 2 exceptions is what, he's moving the first 2 exceptions.
Yeah.
That appear on the
Okay.
agenda.
Yeah.
So I understand, Mel, you're not granting any exception at all on the
For side yard, no, no.
Been moved and seconded.
The backyard was not requested for an exception.
Right.
And it sounds like the neighbors understand that they could build to within 30 feet of the rear yard setback there, 30 feet from Terrace Road. And from an engineering standpoint, I'm sorry, but I'll just say this, we're not the permit and development center. We don't do engineering. I appreciate pros and cons on that, but I think what we're interested in is where it sits, not how it's designed to sit. I may be oversimplifying
My rule of
that.
thumb always is, and always has been, if you're trying to pour 10 gallons in a 5-gallon boot. I don't see that here. That's, I think it's reasonable. 2.5 feet on either side. I'm challenged on that, but.
I
That's
think
just
it'd be
my-
hard to leave even one tree in a side yard yet at 7.5 feet. By the time you pour footings and have to move guys around the side of a house.
That's just my thought. At any rate, been moved and seconded. Is there any further discussion? All those in favor, raise your hand and say aye. All those opposed, motion carries 4-1.
Okay.
All right.
I like your analogy, though.
Item 7 is a special permit and variance at 3931 Cottage Grove.
Yeah, Mr. Chairman, I'm recusing myself on item 7.
Thank you, Tom. So again, we'll be down to 5 votes.
Mr. Chair, I have a hard stop at 3.
Okay. Thanks.
Will Brooke be returning?
No.
Okay. So at 3, we're going to be down to how many of us then?
5.
So all votes thereafter will require 4 to pass.
Right.
So, okay.
We're going to get it now.
Cindy, get
Yes.
Shorter. I mean, it's all written out. The applicant should sign it at time. I agree. I don't know what they're, 10 minutes, that'll get 5.
Mr. Chair, members of the board, the subject property is a residence located on Cottage Grove in the Drake neighborhood. The owner operates a home-based cleaning business where they dispatch crews from their location. They have parking for their employees on a commercially zoned location nearby to the east. But what occurs is the appellant does have them come to the premises and pick up supplies for the cleaning operations from the home-based property on a daily basis, and gives them their assignments to where they go, off premises to where they work. So in this case, we're also having to ask for relief of the provisions within the home occupation limitations that no more than 2 non-residents shall be engaged or employed in the business upon the premises, and then also a variance of the provision for home occupations that prohibit the congestion of business employees at the site. Now, and that's strictly interpreted there based on what they've described they want to do. That doesn't mean that those employees are there on an ongoing, continuous basis, but they do on a daily basis. So staff has interpreted that as needing those variances as well. So they are also in front of you. In looking at the merits of this, you should also know that they have, again, I pointed out that they do have a commercially zoned location where they park their vans, and their employees park when they take vans to go do their work. So they have gotten to the point where they've expanded kind of their enterprise into some property that's commercially zoned. From staff's point of view, based on 4 crews that frequent this site, it's getting to the point where the amount of activity is no longer subordinate to the single-family use of the property. It becomes more of a burden on the neighborhood or an undue impact. And so we believe that the best solution would be to find a commercially zoned location to conduct this operation for the storage and pickup of the the materials and cleaning supplies and so forth. So we're recommending denial of the variances and the special permit. If it was strictly just the office only and everything was dispatched through, wireless radio communication and nobody really came to the premises, I think we'd look at it a little differently. But based on what's being described by the appellant, we just can't support the special permit and variances.
Questions for staff?
Just two brief ones. Eric, you mentioned that the related business also is conducted at another commercial location. Where is that commercial location?
I was hoping it was on the map, but.
Okay, is it kind of nearby?
Just a little bit east of here.
On Cottage Grove?
Yeah, it's on the corner of 3510.
At 3510 Cottage Grove, and does that location have like signage at it? Does it say what the business is? Okay, and
photo, I think, of this.
Okay, and what is
This was controversial in years past when I think there was a coffee house there.
Okay, is there a bike shop at this one, or am I thinking somewhere else?
I don't know what it is. There was
Okay.
a woodworking shop that got the site plan approved.
Okay,
when
all
it
right,
was
and
developed, yeah.
what's the general name of the business at this location?
Valley Services. I think they're exclusively the occupants of that location.
All right, thank you.
Any other questions for staff? Thanks, Eric. Applicant or representative of the applicant?
I'm Charlotte Lee, and this is my husband. He's gonna speak.
I'm Rick Lee. I reside at 3931 Cottage Grove. And we are seeking, well, I guess there's three ways it could go. You could deny the variance, the special permit. You could grant us the special permit, or you could give us a limited 1 to 2 year special permit and allow us to finish the rehab of the building to get into it, so that we don't have to have some of a lateral move financially to try and find another place to operate our business while we rehab the property at 3510 Cottage Grove, which we bought in 2007. Our company is now strictly a cleaning business, but before we did rehab in the Drake neighborhood of homes that were like apartments that were single-family dwellings back when they were built, and we converted them back to a single-family dwelling to try to improve our neighborhood. When this building came up for sale, we had intentions of buying it at a lower price, but somebody bought it out from underneath us who was, I would say, not a person who would be looking out for the best interests of our neighborhood. So we upped it and bought it anyway at a price. And so what happened was we'd probably be in that building right now, but we got caught in that bubble. We were holding on to 2 houses that we had rehabbed during that period of time. And we got caught in that bubble, and we were holding on to 2 houses, and it created a loss for our company, put a dent in Valley Services and our inability to go in and rehab the property. So we are now back to kind of like square one of getting back into the property and rehabbing it over the next 1 to 2 years. And so as far as the variance goes, we never have more than 1 car or 2 people that come to our personal property and leave with their instructions and with their materials that they need. They come in shifts. We do have 4 crews, but they come in shifts. They're never congregating or clogging up the street. They just come in, they're in there for 5 to 10 minutes and they leave. Then when they come back from their work, it's just the opposite. They drop off their material, they drop off the receipts, and they're gone. And then they go back to the parking lot, they get their own personal pickups or their own cars, and we drive passenger cars, little passenger cars that are marked with our company name on the side. So the extent is just that. They come in, they're there less than 10 minutes when they come in and 10 minutes when they leave. So there's not a whole lot of congregating going on because we just got to get them out and get them to work. So we could ask for those. I mean, those are kind of the 3 options that I saw before, is denial, give us the permit, or grant us a 2-year extension on it, or whatever you would call it, to allow us to do that, and so we wouldn't have a lateral move to go someplace else in the neighborhood.
Okay.
We've been in the neighborhood since 1989, so we love the neighborhood. So that's kind of where we're at.
Questions?
Just a couple, Mr. Chair.
Go ahead, Mel.
Okay. Rick, nice presentation. A couple of questions. You say you have shifts now, maybe like 4 shifts, but are they reporting like one at 7, one at 7:30, one at 8, one at 8:30, like that?
Yes, they're.
We're not talking shifts first, second, third around the clock.
We're talking, the reason we do it is for the clarity of what we're trying to accomplish in the morning.
You don't want to trip over everybody at
We
once,
don't want to trip
right?
over, we don't
Okay.
driving in and out. We don't want the neighbors to see 8 people coming out of the house,
Right,
you know.
because I don't either.
Right, and that's, we're very concerned about that. We love our neighborhood.
okay.
And we have very much concern for our neighborhood, and we
Okay.
would never do that.
And this is cleaning service related, so you give them the order of where they're going to clean, you give them some supplies, then they take their own car and they go. Is that
That's
right?
They take their own car to get our cars, and then they leave.
Oh, okay.
We have
so-
our own cars down at the parking lot.
Right. So they aren't, while they're out cleaning, they aren't leaving a car on the street in front of your house?
No.
They're just there
They-
for 15, 20 minutes to get their stuff and move on?
Right, and when they pull our car out to clean, and we have our own cleaning cars, they pull into the spot that they vacated.
Right, okay. And is your ultimate goal to have everything occur down at this building in the picture?
Yes,
Okay, and you've owned that building 5 years now?
yes.
Okay, are you kind of proceeding with your remodeling now?
Yes,
or-
I met with an engineer and with the Erickson Contracting, they're going to be doing the work for me.
Okay.
And we're engineering it next week, so yeah, we're on that path again.
So if I drove by at 10 a.m., let's say, you ought to have all your crews going for the day. I shouldn't see any cars in front of your house except for your own?
No, none. There'll be none.
Just on a typical day? Okay.
There'll be none.
All right, thank you.
Any other questions?
Just do you think that within, you said 2 years, you'll have this building ready for occupancy in terms of your use?
Yeah, that is our goal. I mean, we are back to a stability. Credit's kind of eased up a little bit. You can get a little bit credit for these kind of things, you know, and the building is in pretty much disrepair. It needs a lot of tender love. It's in bad shape, but yeah, that is our goal. It will be in it in 2 years.
Thank you.
Simple building, too.
Is there anybody else here to speak in support? Is there anybody here to speak in opposition? Any last questions for staff? Hearing none, we'll close the public portion and go to board decision.
Thank you.
The city just denied, the city doesn't recommend it. Can I get more thoughts from them as to what your thoughts were? And some of these cards are indicating that the neighbors are not real happy
Yeah,
about
that's what
it.
I think that it's the activity that's going on in the interim. I understand they're pursuing getting this other location online. But I think it's been a problem for neighbors, whether, that's all perception of the people making complaints. But
I mean, neighbors are complaining, and the cards, I mean, it's valid, yeah, I mean, we have to listen to what they're saying, and I just was
Yeah, I don't-
wondering,
I don't
because
think
sometimes you
staff-
support home occupations, and,
I don't think staff really, we didn't evaluate their other location they're trying to get into. It was rezoned at a point in time and for a contractor's office, for a woodworking contractor, and there was limitations placed on it that have been met, as far as I know. If, at whatever point they're ready to go into that location, we'll have to make sure that their site plan is still compliant, all the plant material's been maintained and that type of thing. But in the interim, there's flex solutions that, they can lease a space for a year or something somewhere, I would think. But we just think there's other alternatives, and if we got these types of requests, I think we would be consistent in our recommendation.
okay. Thanks.
Any other questions?
I'm curious about the hours of operation, and I didn't ask that. Would that be okay for me to?
Sure can.
Yeah, if that's already been put out
It's
as
in the
part
staff
of the.
report.
And could you remind me what that is again?
7:45.
8 to 6? 5 days a week, so no Saturdays, so there's no employees there after 6 o'clock at night checking back in, there's no night cleaning crews or anything? Okay, thanks.
Good, Mel?
Yep.
We're still in the board deliberations, so.
I'm inclined to support the 2-year if that's really our option.
I'm not a big fan of home occupations when we got people reporting to places. And parking all day, I just hate that. But it sounds like in this case, they aren't necessarily doing that. If you read the cards, they say, well, they'll park in front of my house, but they don't say they're sitting there all day and taking up my space. I don't get that. And some of the other cards that didn't like it also said they just don't like business encroachment. Well, I'd maybe need a little more. I'd really want to know that, you know, like when we had the bed and breakfast, yeah, there's cars sitting on the street all the time. We're tripping over them. You know, these renters are there all the time. I understand exactly where staff's coming from. I think a residential neighborhood is for residents. I
They're
don't think,
consistent along that line
yeah,
too, so.
yeah, and I think we've all been pretty good with that, but I kind of see where they're going. As, you know, was discussed earlier, I like to take people at face value here. But I'd maybe like to see a term limit on this. You know, and if we see a problem, this is a special permit, so we can bring special permits back, is that correct? Just like a conditional use, if there's a problem or a
Put
complaint?
that as a condition,
Okay.
that you could bring it back.
Yes.
I don't think that's automatically in the code.
Okay.
Can we do a year instead of 2
I,
years, though?
I'm open for discussion.
I mean, we have neighbors that really
Yeah.
are
Yeah.
saying,
Yes,
this
yes.
is not the place to have it.
And I can support that. That's a long time to build a.
Yeah, you can
I mean,
start
they
getting it
building-
figured out.
This building
They need
isn't
to
a
get
two-year
out of it.
project.
Right.
I'm sorry, in the applicable's N would, on home occupations, would require or allow the item to be brought back.
Okay, so
Okay, so it's already in there, we wouldn't need to change anything. Okay.
let me ask, kind of getting a feeling that a year's about all you want to look at. Can you make that work, or is that too much of a hardship?
I mean, if it's what you want to do, we will push hard for it. I mean,
Okay.
not causing us to have a lateral move of investment, I think, is really helpful. So, you know, 2 would be great, but 1 would allow you to probably get the first phase in, which would.
Okay.
Okay.
Split the difference, go 18 months?
I'm still just a year.
I'm trying to find a common ground here.
I mean, it's too many employees. Other businesses, I mean, we all have to have businesses. We have,
Right. But
Okay.
if we had 6 to 8 cars showing up and staying there, no way, no how. This seems a little different.
Okay, let's hear a motion. I'm game.
I think Nell was making a motion.
Well, I'd make a motion to approve the special permit and variance for a period of no longer than 18 months. We'll try it.
Oh, yay. Compromise has been found.
Now, this would have to, we have, how many members here? 6 of us, right?
Right.
Okay, so.
Well, 5 vote.
Oh, he's
recused,
he's still
yeah.
recused.
So we-
All right, so we need 4
5.
to pass it.
Right.
Okay, 4 out of 5. Okay,
And Mel, I'll second that.
all right.
Been moved in second. Is there any further discussion? All those in favor, raise your hand and say aye. Those opposed? Motion carries 4 to 1. You counted your votes well.
And if he's successful, he might have it done in a year anyway.
That's what we're hoping for.
But he's got 18 months.
He's got 18.
All right,
Thank you.
you bet.
Mr. Chair, I'm going to leave. I can come back if it's still going at 4.
Okay, I hope we aren't, but
I hope you're not.
let me just take a quick peek here before you, Jake, let's see.
Can we have somebody contact him if it looks like we'll be doing that? Is there a
I
way-
don't think we'll be.
Can he call Diane?
Can you
Can you just-
going to cut out now, or do you want to try and sit through this one?
Cut out now.
Okay, all right. But when we just
My
had
kids get
discussions, we're going to be down to 5 members, so
What's that number?
it's going to take, you need 4 votes no matter what, that's what we're getting at.
Yeah. 577, 2, 3, 4.
Item 8 is conditional use permit at 4301 Fleur Drive.
Okay.
Item number 8 would allow the All in the Family Tavern
6-8.
to reopen within the Wakanda Shopping Center. It would be within a approximately 4,200 square foot commercial bay that was previously occupied by Corleano's Pizza. The subject property is just south of the Dolls on Fleur. There's McDonald's in front of it, and it's a strip commercial center with a mix of retail and office uses. The tavern would go in this 42-foot wide commercial bay right here. Close-up version view. They would have the standard tavern layout. They are showing dance floor in that area there. Again, the front facing floor is to the left. Here's the sign options that they've proposed. The sign is allowed, they've just showed these for conceptual sake. And then police reports, back for the past 12 months, we didn't see anything abnormal. All in the family had been operating in this building right here up until a few months ago. That building has since been torn down, and so they're wanting to relocate into this building right here. Staff recommends approval. They satisfy the criteria necessary for granting conditional use permit for a tavern that requires 150 feet of separation from any church, park, school, or daycare. It meets that 150-foot separation. There is a Little Sprouts daycare located to the south, but it's over 500 feet away, so it does meet the 150-foot separation. So we've recommended approval, standard to the typical conditions for taverns, such as complying with the sound ordinance, and that it would be subject to revocation if it becomes a nuisance. So, are there any questions?
I see a dance floor, so is there going to be music, or are we going to have the neighbors beating the door down, or?
I would let the applicant answer that, but it looks like there'd be a DJ booth, so I don't know if that'd be live music or just somebody spinning records. But
Any other questions for staff? Thanks, Bert. Applicant or representative of the applicant?
My name's Larry Sly. I live at 3212 Wauwatosa in Des Moines. Speaking on behalf of Helen Gordon, all in the family. She was in the business, as they said, just a few doors down for 38 years, and a very successful business person, and lost the lease there, so just logical to keep it in the same neighborhood, you know, for the clientele. I think we pretty much presented everything in the narrative. So I don't know if you have any questions for me or her.
No?
Larry, you still looking at the same kind of clientele as you had before?
Yeah.
And Helen will still be doing some management?
Exactly.
Okay, and you're keeping the same traditional name? And
Yep.
Okay, all right.
Yeah.
Thank you.
Any other questions?
Are you going to have live music?
There is on Friday and Saturday nights from, what is it, 8 to 1? 9 to 1. 9 to 1, Fridays and Saturdays. 9 to 12, I'm sorry.
And is that any different than your old location?
Nope, same thing.
Okay.
Yes.
Any other questions? Thank you.
You're welcome.
Anybody else to speak in support? Anybody speak in opposition? Any last questions for staff? Hearing none, we'll close the public portion and go to board decision.
All right. As the South Sider here, I can now remember 40 years back, Wakanda was a great place to go to movies at when the movie theater was there, and the ice cream shop's still there. And All in the Family was always down at the end, but I was too young to go there.
Good cover, Mel.
Yeah, but keeping the Wakanda Shopping Center viable and keeping good businesses in there, I think, is important. And we have a good business there. I think it'll fit in fine where it's located within the mall. There's large parking area around it. Don't see an issue with sound, travel issues, you know, traffic circulation. I'd move staff recommendation for approval.
I'll second.
Moved and seconded. Is there any further discussion? All those in favor, raise your hand, say aye. Motion carries 5-0. We'll be,
carry on.
As Mel and I will always say, we'll
Yes.
be down there to check it out.
Yeah.
Item 9 is amend a conditional use permit at 829 Southeast 21st Street.
Yes, and there was no cards that we received, so I'm not passing any around.
Wow.
So there's the consent map. I did want to point out, it is in proximity of Kemen Industries to the north, but that was outside of the notification area. So if you see this red line here, their campus begins on the north side of Maori there. We did their representation because And the reason we did that was because just recently another property was proposed for rezoning in proximity to their campus, which was proposing salvage operation as well. And they did have opposition to that. And so, and it was based on some concerns over because of the fact that they're a food-based industry. So they have federal standards that they have to maintain from a health and food safety standpoint. And so a lot of their concerns with salvage in proximity were with regard to that. So we did make contact to those individuals beyond our normal 250 feet. I didn't get any actual response. I don't know if they're here today to speak to it, but we did advise them, so if they had comments, they would be here today.
Okay.
The appellant is proposing to take the current site, which has a conditional use for recycling operation within the existing premises. That was approved with an addition off of the south of this building, which has not been built. So that actual expansion, the relief for that died. However, they did do some things to improve the circulation and the paved surfaces to meet the standards under the previous approval. So those, you know, some of the site aspects do conform. This highlighted yellow area is the area which the appellant is seeking to use for the metal recycling operation. My understanding is that they were previously operating on the property to the west and now are looking to move to this location within this site as an expansion. Staff's biggest concerns are, at the time this was approved, there was concern about having any type of materials stored outdoors, so it was left that the condition would be that no outdoor storage of materials unless it was packaged, basically. And I described what the relief was given at that time in the staff report, so you can see that if you have any questions. That still remains today. I think we want to make sure that whatever would happen here wouldn't just be loose material that wasn't controlled within the site. That tends to be problematic. It gets into the soil, it gets debris flies around and so forth. So we want any approval to be conditioned upon having things kept in an orderly fashion in containers that are designed for that purpose, so that there is control of the material on the site and it's not just a health hazard or a health problem. Probably piles of metal in their own right don't harbor rodents necessarily, but they provide shelter for things that attract rodents. So rodents always have to have a food source. So otherwise they don't stick around too much. So we are recommending in favor of this, subject to compliance with provision of a site plan amendment to reflect what they're doing. They would have to show that their access and maneuvering is on a paved or dust. The storage would be on a dustless surface. We still want to prohibit any outside storage of unpackaged materials except for metal materials kept in durable bins or containers designed for such purpose or kept in transport trailers that are used to and from the site. We want to limit any recycling operation to the processing of waste and salvage metal and paper products, which would include the existing use of the site as well, so that any additional types of material they're seeking to recycle, they'd have to come back in front of the board to get another amendment. And then at any time, should the zoning officer determine that the business is demonstrating a pattern of negative impacts or constituting a public nuisance, the conditional use shall be brought back for board consideration. I'll give you a couple photos. You can see this is looking at it from Southeast 21st Street. So if you're driving, this is the public street right here. Maury's up here. You come down Southeast 21st. Mm-hmm. The gate accesses to the site are at this location, and then there's a loading area here. So this photo looks at that south gate looking east So basically, this area where I'm pointing with my pen would be the area they're looking to have the metal recycling operation. This is the existing site looking more toward the north, so you can see where that docking area is that was on the aerial overhead.
No?
And then this is zooming more directly into that area where they would do the recycling operation.
Eric, have you discussed your conditions with the appellant to any degree?
Not since we've developed the staff report. We did have a pre-app meeting with them.
Sure.
And I think we were clear that we would probably ask for such type, such conditions, but, and we didn't get any, once the staff report went out, we didn't get any calls of concern at this point. That doesn't mean they don't have
Okay,
concern.
sure, we can ask them too. All right, thank you.
Any other questions? Thanks, Eric. Applicant or representative of the applicant?
Good afternoon, Mr. Chair and members of the board. Yes, I'm James Sarcone, 803 33rd Street in Des Moines, Iowa. We have the staff recommendation, and we feel that we can comply with everything. As I stated, the property to the west, I previously owned and operated a business on that site. We never had any problems with the city as far as debris, being a public nuisance in any way. Plan to continue that same reputation over here.
Sure.
And the packaging and those things that are required, and not leaving materials outside. Thankfully, XYZ was also ABC Metals and Recycling. That's what they do. They provide roll-off containers and other things. So our site is full of nothing but containers, and that's where the material will be kept, as it was before at our previous site. So minimal processing will occur at the facility that I think, and that seems to be the neighborhood. It is the neighborhood I want to be in. Thankfully, that's kind of the neighborhood where most salvage yards are put. If you look all up and down Moines Street and the like, that's where most similar businesses are located in town here. So I just look for your approval on this, and hopefully I'm the owner of the newest salvage yard in town. So
Thank you. Any questions? Thank you.
Thank you.
Anybody else here to speak in support?
Dan McCoy, 829 Southeast 21st Street. My family owns the property. I just wanted to reiterate that it's a vacant building right now, and we would appreciate the opportunity for the income from renting it. Thank you.
Wise choice. Thank you. Anybody else here to speak in support?
Mine is not in support or denial, just for a little clarification. My name is Randy Crow of 826 Southeast 21st, the property across the street. And there was comment of moving the business that was currently on our property. Jim has left that operation and is moving across. And I was asking for clarity. I don't know how to pronounce it. XYZ is ABC, owns that property. And it speaks in here, excuse my glasses, but I'm getting old.
I feel your pain.
The proposed use function would be independently of the paper business. I guess my question is it different ownership? XYZ is the one asking for the permit. What is the appropriate nature? Should the business that's actually going in and operating the scrap metal facility, should they be the ones with the permit? And it's just basically a question for clarification.
That's good, staff.
Yeah, XYZ is the property owner. So you're actually giving the conditional use to the property owner.
Okay.
And so that carries, if they have a different vendor or different operation that would come in doing the same thing, they could interchange.
Right.
So
XYZ just
it's
let
not-
their vendor
the
speak.
You're not granting this to the business that's going to operate necessarily unless they buy the property.
Okay.
That clear, Randy?
It is, and XYZ, we're good neighbors, we've been neighbors. I was just looking for specific clarification, knowing in fact that a different business was going in that property, what the appropriate permitting is, and it was explained very clearly.
Never hurts to ask. Thank you.
Thank you.
Is there anybody else here to speak in support? Anybody here to speak in opposition? Any last questions for staff? Hearing none, we'll close the public portion, go to board decision.
again, as the South Side guy, Ward 4, I would move approval of the requested amendments to the conditional use permit, as well as the exception for the front yard setback, subject to conditions 1, 2, 3, and 4 as presented.
I'll second.
Been moved and seconded. Is there any further discussion? All those in favor, raise your hand and say aye. Aye. Motion carries 5-0. Pays to be good neighbors. You got a good one. Item 10 is a special permit and variance at 901 East Douglas.
Pardon me. Where is this? What happened to item 10?
And did you give me copies of this? I'm going to hand around, I'll hand you the original.
Oh, yeah.
We got a letter from Highland Forest Association.
Okay.
It's Southeast 17.
And then I'll give you the cards we received. This particular property is one of, I think, 6 total that are currently owned by the Municipal Housing Agency. It's hard, might be a little hard to see on this aerial because it's kind of dark, but maybe your screen's a little better. So the gold is the property we're dealing with. Along with it, but not part of this relief, are duplexes to the east and then within the cul-de-sac to the south. And those were city-owned housing, or they are city-owned housing. The applicant or appellant is looking to occupy those duplexes, reoccupy them, renovate them, ensure that they meet rental code. Then they would rent those under certificates to their clients, basically. So they would stay, in the eyes of the zoning ordinance, they stay as rental duplexes, basically. But what they aren't able to do, which they're now asking under the special permit, is convert one of the duplexes into a building used for office use and services such as counseling and training. So it would become kind of an assembly, small assembly use that would serve only those individuals that are residing nearby that are the clients of the program, which is a program designed to help disadvantaged women and with their families, children, learn life skills and get integrated back into society. So, and I'll let the appellant give more detail on what their operation is, but from our perspective, staff looked at this and determined what are the impacts that this is going to create. And converting this would have to be done under the building code. There would have to be some commercial modification. Accessibility would have to be added for access of the individuals coming to the property. So you'd have to have accessible bathrooms, things that would have to meet normal assembly. Assembly is not the same as a residence. So when they have meeting space and so forth that members of the public may or may not come to. And these tenants would generally be seen as members of the public by the building code. This is looking more down the cul-de-sac. Staff believes that, from a visible standpoint, it's probably going to have little impact because you won't see much change. It'll still have a residential character to the building. Some of the use of it will be a little more intensive than what's going on with the duplex because more people will be coming to the site, including a couple employees on a daily basis. But given the fact that this is on the corner, Douglas, the entire cul-de-sac basically backs onto the East Euclid commercial corridor, which is a high traffic volume corridor. So any actual traffic that might be generated is either getting out within 2 blocks to East 14, within a block and a half to East Euclid. So staff really isn't concerned about traffic impacts as a result of this. It's probably not going to demand any more parking congestion either because Most of these individuals are not going to be driving their car to this site because they'll be within walking distance. So even if they have a car or access to a car, they won't be frequenting this site with a car. So from that perspective, and as long as the hours of operation are reasonable within normal business hours of the day, staff didn't think that this was going to present an undue burden on the property. So in looking at it, we are recommending in favor of the special permit. And I think the verbiage on that probably should say, for a second I thought it said conditional use permit, but we're recommending approval of the special use permit. We want to ensure that the conversion of the building meets all the commercial codes that it should, that any training center is restricted to employees of the program and its beneficiaries residing within the 5 two-family dwellings. We don't want this to become the source of the center of operations for satellite locations. I think that starts to become a little bit more of a burden on the neighborhood if you start doing that. If they're going to do that, they probably want to look for something nearby in the commercial areas.
Mm-hmm.
Any operation should be restricted to the hours of 7 a.m. to 10 p.m. Again, we're sort of recognizing that there may be some evening meetings or something that occur within a reasonable time in the evening, and that it be brought back to the board if it constitutes any type of a nuisance.
Mel?
Eric, you mentioned previously that this was public housing, and it will continue to be that. What kind of public housing was it before? Was it just like a Section 8 program or something?
Doug Romig is here. He's our Housing Services Director. I'll probably let him comment on that. I don't believe this will remain as public housing in terms of being considered that.
Right. You've given a little summary of it here, what it would be. I'm just curious, if I compare to what you're doing now to what had been occurring, that's kind of important to me.
Yeah, and I think I'll let Doug speak to that.
Okay.
So he can describe the clientele of that housing.
Thanks, Eric.
Chairman Gray, members of the board, Doug Romig, Housing Services Director. This particular location is what's called public housing, which means it is a rental housing unit that's owned and managed by the Housing Services Department. We have one tenant left in one of the units that would transition to a Section 8 program. This is in what is called our disposition approved application, so it is for sale. We did host a public meeting with area neighbors. We sent out to 250 feet, and I think it's referenced in the letter from the Highland Park Neighborhood Association, as we did try to do some outreach prior to moving forward to this point. So currently it is public housing. The sale's pending. This is one of the conditions of the sale as part of their operation.
Okay.
Eric, would you put the consent map up too? Any questions for Doug?
No. Thank you, Doug.
And Doug, I'm assuming you're the applicant, so I just need to find out, is there anybody else here to speak in support?
Chairman Gray, member of the board, thanks for your consideration of this. My name is Brad Whipple. I'm the director of the Iowa Homeless Youth Center's current lighthouse location, which we're looking to relocate here, is 1216 and Martin Luther King Parkway. This is a transitional living center for 16 to 25-year-old parenting or pregnant moms. Those moms can stay there up to 2 years. We focus on 5 key things that we think will assist them in making a successful transition back into the community. We focus on education, employment, life skills, positive community engagement, and safe housing. We think if we can focus on those key things, they have a great shot at making a transition back into the community. We've seen 90% of the youth that we served over the last year leave employed and transitioning into permanent housing. So we have a great track record to run on. The purpose of in the use for this office space really is for 24-hour supervision of the moms who are there. We think, one, it provides a security to the neighborhood, as they will have someone to call 24 hours a day if they ever have any sort of issue. But it also allows us to assist those moms and provide them the support that they need, and also allows us to monitor the expectations that we set for them in being part of the program. So just to give you a little bit of a background there on what its use is and what we do at Iowa Homeless Youth Centers.
Good. Thank you.
No
Mel?
question. Just a little curious, Brad, on how some of this might work while we're talking about either pregnant women or mothers. Where do boyfriends, husbands, ex-husbands, male members fit into this picture?
Well, we don't allow the mothers to have overnights, have any men overnight. Those, they're limited to 2-hour visits.
Okay.
So there's check-in and out at the office periods of time. They're regularly monitoring those units, so the staff who are there will be checking every 1 to 2 hours into the units to make sure that everything is going the way that it's intended to. At our current location, it's something that we've addressed, have policy to address, but really haven't ever had to act on it. So.
Okay, excellent. Thank you.
Any other questions? Thank you. Is there anybody else here to speak in support? Is there anybody here to speak in opposition? Any last questions for staff? Hearing none, we'll close the public portion, go to board decision.
Well, this is my neighborhood, so I'll make a motion to move staff recommendations. I think it's good for our community, it's good for the neighborhood, so we totally support it.
Do we hear a second?
I'd second that with a note that one of the neighbors had mentioned a concern about comings and goings and bad people around. It sounds like this is going to be, not that it was managed improperly before or anything, but this sounds like a really nice thing in a neighborhood, and I doubt whether we'd have the kind of issues that maybe he observed in the past. So, strong second.
Okay, been moved and seconded. All those in favor, raise your hand and say aye. Motion carries 5-0. You'll be driving by. And looking out in the audience, we're going to have quite a last item here, I'm afraid. Yeah. Item 11 is an amendment to a previously granted appeal at 408 East Thornton Avenue.
This item is a request to amend a previously granted set of appeals, and I'm going to go through the history shortly. It's the third time this site has been before the board in the last 5 years. So the site's located along, this house is oriented towards East Thornton Avenue, but it has frontage on Fleetwood Drive to the north. It has double frontage going through. They've built a 40-foot by 60-foot accessory building in the rear yard of this property that's accessed by a driveway from Fleetwood Drive. This property originally came before the board back in January of 2007. At that time, they were looking for the appeals necessary to build a 40 by 60 foot accessory building that would be 20 feet in height. At that time, the board granted the area, but denied the height, which limited it to 17 feet. So,
Glad you highlighted. I remember that.
And part of the approval, the board put the conditions that the accessory building had to have horizontal lap siding and asphalt shingles, and it had to be limited to 17 feet in height. And I'm just going to quickly go over the materials that were presented to the board at that time. Here's the original site sketch. North is down. I apologize for that, but originally they were going to orient the building east to west. Later got built oriented more north to south. And just some photos of the site at that time. You could see just a chain link fence along Fleetwood Drive. House from East Thornton. At that time, we had.
Would you flip that back and show me the offending building?
Well, these pictures were submitted at the time.
Before it was constructed.
So this is before.
Oh, okay. Yeah. All right. Thank you.
Back in 2007, it was all support for the 60 by 40 garage. We had about 8 cards come back in support, and the applicant also submitted a petition signed by quite a few of the neighbors supporting it. So the original consent map, when the board allowed the...
Bert, before you go on a second, can you go back to that? I saw the Pete and Esther Leo. It was one of the cards.
They came in this...
Flip back. No, the other way.
You want the actual card? There were a
Well,
couple
no,
of
they
cards.
did a copy of the card, I thought.
Oh, okay.
Let me see. Yeah,
One
more. I guess another one. There we go, the bottom one. Now, when this card went out and it came back in approval, did they know that the conditions that we were going to put on it at that time, or?
Not that I'm aware of. At the time, it just said it would be a 40 by 60 garage.
That's 20 feet high?
Yeah, it's 20 feet tall.
Okay.
Yeah.
All right, because this letter is,
Yeah, it looks like they actually signed the petition at the time as well.
okay.
The consent map was very positive initially to allow this garage. However, at that time, the board did put the conditions that it had the lap siding and the asphalt shingles. Fast forward a few years, they ultimately constructed a 40 by 60 foot garage, but it didn't have the asphalt shingles or the horizontal lap siding that they were supposed to have, and it exceeded 17 feet. It was 18 feet 3 inches tall. So in November of 2010, it came back to this board. First part of the appeal was to get the exception for the height. Second appeal was to amend the conditions to allow them to keep the vertical overlap siding and the steel roof. At that time, the board did grant the exception to the height, which allows them to have the current height, but you did keep the conditions on it that require the horizontal lap siding and asphalt shingles. And at that time, you also put the condition that any driveway extending from the north wall of the accessory building to Fleetwood Drive, including the drive approach, shall be paved. And I'll point out they've partially complied with that, but they haven't paved from the north wall of the building to the drive approach. But so last this board left it, they did have to put the horizontal lap siding and asphalt shingles on. And then here are some photos that were taken at that time. You can see they had the fence, but the evergreen trees that they've since planted don't show up back in 2010. Here's another photo. Again, up front here, this is Fleetwood Drive, which they have frontage on it, but it functions as the rear yard for the Phelps property.
And I remember, wasn't there some talk before about that
Yes.
curb cut that was there, that we allowed it or we didn't,
Well,
or?
by right, they could have one driveway from Fleetwood since they have a frontage, but the board said that it has to be paved from Fleetwood to the
Right.
north wall. And they have, the current photos I'll show you, they have paved a part of it. So they did comply with a portion of that. So just showing, you can see the view from East Thornton. The view of the accessory building is fairly minimal. And then this is looking down Fleetwood Drive. You can see the houses. This is looking east, the subject property, the accessory buildings right here. You can see, for the most part, it's a very residential street, with the exception of the Phelps building fronts it. And this is just showing the majority of the houses on Fleetwood all have horizontal lap siding, which is where that condition for the horizontal siding came from. And then back in 2010, there was quite a bit of opposition to it.
What was the opposite? They're signing something, what does it say? What are they signing the objection to?
Variance objection.
There wasn't any preamble to these signing pages?
No.
Okay.
But this was from our hearing in November of 2010. Okay,
This is when they came back and said,
for the second.
Please remove the condition
Yeah.
for
Yeah.
horizontal siding.
They say we build it and waive your conditions.
correct.
Yeah.
And this was the consent map at that time.
Which is everybody that can see it is objecting.
Right. Okay, now fast forward to where we are today. This is another view from East Thornton. Again, the view of the building from East Thornton really is minimal. It's more from Fleetwood where we have the impact. This is the current view. You can see that, I guess you probably can't see it on that photo, but they've put the horizontal overlap siding on the north facade. So they comply with the condition on this north facade. However, the side facades are still vertical siding and they still have the metal roof. So at this time, they're asking for the board to waive the conditions for the asphalt shingles and the horizontal siding on the sides. And then this is looking straight south from Fleetwood Drive. There's a row of evergreens that they've planted between the solid wood fence and the front property line. And then this shows the portion of the driveway that they've paved. Again, the condition from 2010 says they have to pave all the way from the north wall of the building to Fleetwood. So they've paved this approach, but they still have a little bit of paving to do there. This is dark. Then our consent map today, again, the people who are most visually impacted are still in opposition.
Could you show us, compare that consent map to the previous consent map?
Or to the first one.
No, just to the one that we had back in 2010.
The November 2010?
Yeah. Okay, now, there's just been no reply from two people, right?
Three.
Okay, three.
And it looks like owner names have stayed about the same for those that did not reply again.
Yeah, all right.
Okay.
You have one, Mel?
A question that I have, and when he goes down to get his permit for this, does the inspector say, hey, you know, you've been granted a variance or an exception and you can't go above this height, but he did it anyway?
Well,
I mean,
I'll let the applicant explain to that. There was some health concerns with Mr. Phelps, so Mrs. Phelps ended up being the one to use the board's relief and construct the garage. Initially, there was a building permit issued. When the inspector went out, they failed that because the footings weren't right. Well, then the next thing the inspector knew, the building was constructed without the necessary inspection. So
That's what I remember. They got one initial inspection and then never called again.
right, and then it was up.
If, I have a question. If we enter an order that says tear the building down, either, comply or tear it down, what do we do about the approach? They've put in a cement approach. Does that just stay there? I mean, that's not real offensive to me, but.
No, and since they have a frontage on Fleetwood Drive, they are allowed to have
an approach.
drive approach there.
Yeah, okay. All right, thanks.
Bert, when we granted some variances but also some conditions in November 2010, how much time were they given to complete those modifications?
It would have been 2 years.
Okay, which brings us to about where we're at.
They're here.
So, and yes, to drop the other shoe, then did the appellant voluntarily say, oh, I'm out of time, I'm going to come back? Or was there some kind of inspection or enforcement?
And I know Sue's been working with them.
That
I
had
don't
kind
know
of-
if she wants to address it, but over the last 2 years, Sue has
Okay.
been.
So there's been some engagement over time here.
And
Okay.
Like I said, they did switch the siding on the
Sure,
north facade.
Sure. Okay. And that's fine. We'll let the appellant, maybe Sue can add something to that. All right,
I
thank
would
you.
like to hear, just before we go on,
Yes,
hear what
yes.
Sue's side is.
Chair, members of the board, at the end of the 2 years, or toward the end of the 2 years, we did get a complaint from the neighbor regarding failure to comply with your last order, which triggered a notice, which brings us back.
So there's a
So somebody's
complaint.
watching it pretty closely.
Okay.
Yes.
Okay. All right.
Thank you. Any other questions for staff? Thanks, Bert. Applicant, representative of the applicant?
Good afternoon, Mr. Chairman, members of the Board of Adjustment. Dan Manning, 317 6th Avenue, Suite 300, Des Moines, Iowa, with the Lillis O'Malley Law Firm, and I'm representing the applicant Barry and Natalie Phelps concerning this property and this request. I guess what I want to be clear about and make sure that the board understands is that in this instance, there were some issues and some mistakes made along the way, but we want to be at least clear with you as to why those mistakes were made. And that, first of all, Mr. Phelps, Barry Phelps, came here and got the permit that was talked about first. Then he suffered a brain injury in a motorcycle accident after the permit was approved, and really unable to function adequately or to ensure that this building would be put up. Natalie, who's present today, took on that responsibility to get this building constructed, and did have contact with the city and did talk to the inspectors, and we've got a building permit here that that was signed off on by the inspectors. So we don't agree that with all the facts as laid out by the staff. I think we agree with the basic facts, that they came and got the permit, and that the property was ultimately built. Went through Natalie, given this job to build this structure, talked to Menards. Menards, she wanted the vertical siding, not to defy this board's authority, but because that's with the existing garage that they have at their home, that's how it is. That's how it looks. The color and the shape and this is not, at one point there was a conversation with steel siding. It's hardy plank that was put in. It's a quality material that was put in, and it's consistent with the garage. I mean, that's how vertical siding got put on the house, so that you're clear about why that happened and how it happened. Then, in talking with the folks at Menards who she contracted with to build this facility, they shared with her how the steel roof would work, that it was, the term obviously green, that if she applied, she could apply and from the state get because it was green, get a rebate from the state based upon the fact that it's more efficient and so forth. That's how it was done. There's been an allegation that the building, we're operating a business out of that building, and that's not true. I mean, there's no electricity in that building. It's used to store vehicles. So we want to make sure that we're at least clear with each other as to what the facts are as we move forward here. And we've received a bid to what it would cost to remove that roof, and it's over $20,000. I have it. We can make it a part of the record and submit it to you. I mean, I've been around a long time. I know that when the board puts a requirement, insists upon something, that's not an idle request. That's a demand. That's what you're supposed to do, and we understand that. From our perspective, what we're suggesting to you is that and we have had conversation. I say we, not me, but the Phelps have had conversation with zoning enforcement. Sue Ann Donovan. I mean, not just last month, but over a period of time. We have put an approach in. I guess I just had a conversation with my client. Our understanding that the approach that we put in was adequate. Okay, but obviously if we need to put that approach in to actually to run, up to and abut the building, then that's something that we'll do. It wasn't my understanding that that was something that, in fact, the approach was something that we wanted to make sure that we had done and that we done correctly and done appropriately. The lap siding, you know, we have modified it along the north side of the property. We put in 13 trees along an 8-foot fence that, along the north side of the property in an effort to beautify and buffer this property. So we are trying to comply, and I just want to, I want to be clear that what I see in my short term of representing Mrs. Phelps primarily, I've met Barry, but I'm dealing with Natalie, is a person who's frankly, with this, you know, caring for her husband, kind of overwhelmed by all of these requirements. We recognize that we're down to two things. We're down to, I guess maybe three now. We've got to fix that approach. And we've got to, I guess, and I know that there are neighbors here supportive of the Phelps, and we'd like to, if you wouldn't mind, have them approach you, have them give you their names and let you know where they reside along this property, or in relationship to this property. You know, I guess I, more than most, respect the fact that you put conditions on this family, and you allowed them to, they came back to you with a problem with the height, and you addressed the problem with the height. So I'm fully appreciative and understanding of where this board has been taken in this process and where you are now. So, but I just point out to you, and I guess what I'll do, with your permission, is just ask, just so that we have a complete record, is that there's I didn't think this was necessary, but Natalie got a letter from the doctor as to why Barry's not here. Well, Barry, you know, just can't be here because of the stress he's under and so forth. And we have this estimate. Can I approach you and present?
Well, put it under the...
Mark it as an exhibit and put it under the thing, and it'll be part of the record.
Thank you. Okay, this is an estimate from the same man who constructed the property. I don't know if you can get that close enough. I can tell you what those numbers are. It's the bottom line is $22,000, and I think.
He can do that now.
Okay. You know, there's quite a bit of.
Dan, could you number the exhibit rather than Exhibit A?
I'm sorry. Make it 1.
Yes.
Okay, I'm sorry, thank you.
The city gets A, right?
City gets A? We
Yeah.
get 1? Okay, thank you.
Your number.
So what we're showing you is that I mean, I've read the record, I understand it. There was no ability really to say that you weren't clear. You were clear that there should be asphalt shingles on the roof. And you were clear that there should be horizontal siding on the siding. But as I go on, I look at that and I recognize that was your directive. As I look at it, it's exactly like what they have in their garage, on their garage. It's the same color. It's hardy plank. It's a good quality product. They've put the lap siding horizontally on the north side of the property, and wouldn't try to tell you that we can't do it on the other sides of the property if that's what you deem appropriate. But from our perspective, to require them to take a green roof, recognize it's steel roof, at the expense that we're talking about, we're simply asking that you not make that a requirement. And I guess I don't have anything other to present other than I would like at this time, if it's appropriate, to have these folks come forward unless you have questions.
That'll be fine. I've got a question. And this came out, Mr. Clark kind of had the same notion I did. If I remember the timeline correctly, Barry was here and then involved in a traffic accident after that. The person that went to get the permit was his wife. Is that correct? I don't recall Barry going and getting the permit.
My understanding is he got the permit and he had the permit. That's my understanding of the facts.
Which would also have our decision with it. It's not a separate.
No, I'm sorry. From the 07 decision, you mean?
Right.
Rather than the 10?
Right.
Okay.
Yeah, the 07.
Yeah.
That's what I'm talking about.
Okay.
I'm sorry.
Back in 07.
Yeah.
Okay.
That's and so even if she had this deal with Menards, she had to have the permit, and she had to have the board's decision on that. So somebody made the decision at that time to, well, we're not going to do this, we're going to do it this way. And I think that's why it was back to us in 2010, is why? I mean, you had everything, every opportunity there. And the second thing that troubled us at that time was why they didn't take the inspection past the initial footings inspection. The last week, so I don't think they're trying to deceive us, but on the same token, you're not leaving us with any latitude to give us any leeway on this.
Well, let me tell you, I'll do my best to answer that question. And Natalie, if I misstate the record, please come forward and be clear about it. But what my understanding is that I don't honestly know procedurally whether, when she was issued the permit, then she was then issued the conditions that went with it. I don't know if that's exactly how the city does it or not. But I do know that Barry had obtained the permit. Barry got hurt. She went forward and had some neighbors kind of helping her go forward with getting this thing built. She had, this same person who built the structure, who's giving us this bid here, is the person who helped her. Okay, so Barry was of no assistance in moving forward at that particular time. There was an inspector who came out. We have an inspection permit here. What she was told is that there'll be a permit when this is all completed. When this is all done, there'll be and I don't mean a permit, there'll be an inspection when this is all done. But you've had this initial inspection. Go ahead and pour your footings, and then go ahead and build the building. And then there was a conversation with Menards as to convincing her, in essence, a conversation, why don't you put in a steel roof?
Excuse me, Mr. Manning, let's stop right there.
Okay.
Did she hand Menards the order from this board and say, I want to build something, and it's got to comply with this order?
I'm confident that she did not do that, Mr. Clark.
All right.
Well, good.
Okay. I'm confident that didn't happen.
Okay.
And as I pointed out, there's some things that obviously should have been done differently in this process.
Dan, a couple questions to understand how things do look now. From the city's perspective, they don't really enter the property to take pictures close up.
Right.
Do you have any pictures that show the siding that was installed properly and how that looks, or how the siding does look on site the way it is now with the vertical siding? Do you have like anything that shows the improvements you have made to date?
We don't. We don't.
Okay.
We have the photos that the staff has that shows the north side of the property.
Right. Which they took from the public right-of-way, I think. And we said in November of 2010 that we basically said you don't have to cut 1.5 feet, gird the building, and cut 1.5 feet off it and drop it. I mean, I can only imagine what that would have cost you to do that. That was the relief we granted you at the time. And we wanted these other things done. But we also said at that time that the structure still must comply with appropriate building permits and, building structural stuff. Did you have to make any cost changes or amendments in order to meet those requirements, like with the footings or anything?
No.
So basically, even if the footings didn't have the right permit at the right time, it still turned out okay for you?
Yes.
All right. So really, so far, you haven't had any extra cost to this since it was built, aside from starting to comply with the horizontal siding and starting the driveway approach.
Right. They purchased the enough siding in order to do that north side based upon the conversations that we had with Sue Ann about what we would do. And that's right. And I saw, that they'll have, to the extent that the board would insist that the horizontal siding be placed, they'd have to acquire that.
Okay, all right, for the other sides.
That's
But at least you got it for the north side, and
That's right.
it's partially on there now? Or-
Yes.
Okay.
Yes.
All right.
Now, I was, just to be clear, I was just out there today.
All right.
Now, it's always best to go the day of a hearing, I
Yes,
think.
yes.
Make sure that you get everything that we understand.
And
Is
current
that-
pictures would be even better than
That would be. That would be.
for next time.
That would be. But the lap siding on the north side is not all the way down to the bottom of the, it's down below the 8-foot fence.
Sure.
So that there's no way that visually you can see.
Is that the reason it stopped?
Well, it's because they have the siding there. I mean, they'll certainly do it all. They'll, if the
Because
board
I usually
insists
side
upon
from the bottom and go up, but that's just me.
Maybe you do, from the bottom to the top.
All right, thank you.
One other question, Mr. Manning. The metal roof on this structure, is that a matching roof to the garage?
No.
Okay, so the only metal roof on the premises is the one that somebody sold her?
That's correct.
Okay, thank you.
That's somebody, that's correct.
Any other questions? Thanks, Dan.
Do you want to have any?
I'll go through the routine.
Okay. Okay.
Is there any kind of contractor here or the guy that provided this cost estimate? Is there anybody from an engineering perspective here on your client's behalf?
Anything?
No.
Okay.
So we'll follow the procedure.
Okay.
Yeah. Are you ready?
Yeah. Going to ask anybody else here to speak in support. So I'm assuming you're here to support.
My name is Natalie Phelps. I live at 408 East Thornton Avenue. With my permit, if that paperwork was ever there, I did not have that information, and that's all I want to make clear. Because had I have known and where I have been and what I have sustained in the last 3.5 years of my life, I would have never done this to myself or my family. I had none of the paperwork, and my husband had no knowledge to be able to tell me if it existed. And that's all I want to make sure that I make clear. Because when I went to ask for what to do, I did not have those things. And I apologize for that, and I have taken full responsibility and admit that I did not know, but I do know now. But I just want it clear that I did not have any of those papers ever in my possession to know. All I knew is that he asked for a variance for a size and nothing else, and that was it.
Okay.
Were you here at the initial meeting back in 2007?
No,
Okay.
I was not. This is the first time I've ever set foot in this room.
Okay.
But Natalie, were you here then in November 2010?
No.
No, you weren't, because at that time, and I would not want you to go through this again either. I mean, aside from the building issues, you know, all the things you've had to do for Barry since then, I can only imagine. But the conundrum that I think I have here is a lot of that laundry we've already aired.
Yes.
So when we got to November 2010, we understood you didn't get it. We understood you've had some challenges, but we said going forward, we want you to do this. And that was a 6-0 vote. I'm kind of confused what didn't add up
At
here.
that point in my life, I had a husband that I did not understand everything about a traumatic brain injury, and I'm not going to tell you that I do today. Okay?
Okay.
That felt like he couldn't stand up, defend, and represent his own family.
Okay.
And he felt like he needed to try.
Okay.
And I have learned since that his brain cannot process what you're saying to me right now. He can't break things down. That's why he texts. That's why he writes. He cannot go in a verbal back and forth conversation.
Because in November of 2010, was Barry here? I'm
Yes,
trying to remember
and
who
he did
presented.
try.
Okay.
And he did break down, you know, and broke down.
Right.
I have to live with that regret.
Okay.
And I can't go back and change that either.
Okay.
Because had I have known then what I know now and
Right.
understand now, I would have never done it to him.
Okay. Or maybe you
Or
would have
made
been
him
here in
ask
November
for his thoughts.
2010.
Exactly.
Right.
I would have never.
And you might have said then, hey, if you guys require the shingles, I don't know what it's going to be, but I know it'll be too expensive for us.
Right.
Is what you
Exactly.
maybe would have said then.
Exactly.
Okay. From an engineering perspective, one thing I see here, they talk about roof demolition and then coming in with new wooden roof framing, okay? And I've framed garages 30 by 40 myself. I don't know how your roof framing works now from a steel perspective. Is there any way?
Total different construction.
Okay, so
Spray
there's no
metal.
way that you could just
No.
come in and put some sheet
It's a
plywood on
total
it?
different load-bearing structure.
Okay, so if we put sheet plywood and then shingles, we're going to have problems.
Exactly.
Okay, so you'd have to tear off the whole top of the garage
Yes.
and start over. Okay.
That is correct.
New trusses and
Yes,
everything, just
that
like
is
he's got.
correct.
Okay. All right, because aside from your wind-powered ventilator there, it sounds like everything else is very necessary then to construct a sheathed roof with
Yes.
asphalt shingles. Okay.
Dan, would you pass Exhibit 1 around here, please? Thank you.
Any other questions?
That might be cheaper, scrap it out.
Thank you. Anybody else here to speak in support? Is there more than one person that's going to speak in support? If you don't mind, you can just line up over there. You're right against the wall. Thank you. Thank you.
My name is Carla Houseman. I live at 400 East Thornton. I live directly west of Natalie and Berry. And I am totally fine with the way the building looks. I like the siding. I like the roof. I like the fact that it's green. And I don't feel that there's really any necessary reasons to change it. Thank you.
Thank you.
I'm Marilyn DiMaggio, and I live at 401 East Thornton. And I agree with Carla that I see nothing wrong with the building. As a matter of fact, if you put horizontal siding on that, it's going to look really weird from my house, because the garage and the building right now blend together perfectly. Thank you.
Thank you.
My name is Martha Blackford. I live at 345 East Thornton, and I, too, support the building. I see absolutely nothing wrong with it. In fact, you can't see that much of it from any angle.
Thank you. Anybody else here to speak in support? Anybody here to speak in opposition?
Good afternoon, evening, ladies and gentlemen. Frank Hardy with the Nyemaster Law Firm, 700 Walnut, here in Des Moines. I'm here to speak briefly on behalf of my mother-in-law, Esther Leo. She lives at 3515 Truber, and their front porch actually faces this building. And I'm just going to make a couple of points, and I'm going to let my father-in-law, Pete Leo, make a couple of points on his own. Esther wishes she could be here. She could not. And I know a lot of this is old history. My nephew was helping my in-laws with this for a while, and I'm kind of late to the party. But Esther does say that what she approved originally and why there was probably some difference in the original approvals, the signatures, and then you probably wondered, well, why, if everyone knew that there was going to be this structure, why did they all come back later and raise a concern? They were told it was going to be a three-car garage, and that, whether someone described it a certain way or not, that obviously conjured up a vision of a three-car garage, which is different than an 18-foot high, 20 by 40 outbuilding. But I think that's history here. The bottom line here is the standard that this board has to apply. The key language is not of the owner's making. And this hardship, unfortunately, and it's a terrible story. That is tragic. But as you know, when you talk about who the owners of record are and what their responsibilities are and what this board's responsibilities are, the owners are supposed to be on notice of not just the zoning, but of the decisions of this board. And not only are they supposed to be on notice, but, and this may be the answer here, they've got a darn good lawyer in Dan, and maybe Menards or this contractor whose name I'm not quite clear on, it's their responsibility to make sure that a structure that they sell to somebody and that they build is compliant with not only the zoning, but your very clear directives. And that's, if there's a culprit, and people look for culprits, I'm not saying there is, but if there is, that might be who it is. But the bottom line is, if you look at the folks who obviously support their neighbors, they don't have to look at that building. I mean, if you look at where they reside, they don't even see it, because those are nice, big, deep lots. And that building is right in the front of the folks on Truber, and those are the folks who are objecting. With that, ladies and gentlemen, I'm going to bid you good evening.
Thank you.
Can I ask him a question, Frank? since you sat here for so long to begin with. Question for you, and I'd ask this of the appellant. Do you have any photos from your, not necessarily your client's perspective, your in-laws' perspective, any photos that show what is their view? What do they see? What is objectionable?
No, I don't, but I'll let my father-in-law describe it,
Okay.
if that's okay.
That's fine.
Sure.
Okay.
Thank you.
My name is Pete Leo. I live at 3550 Truber Place. And I've been here 2 years ago. I think this lady here had the right idea. Tear the damn thing down. Well, we didn't. So we're
Mr. Leo, if you'd speak a little more into the microphone, just
Pull it
come
forward.
That's right.
There you go.
Forward a little
There
bit
you go.
so we can hear you.
Okay?
Yeah,
Better.
much better.
Thank you.
Very good.
Well, anyway, everything's all in wrong perspective. My wife signed a petition 2 years ago, 3 years ago for a 3-car garage. So did all the neighbors in that neighborhood for a 3-car garage. No one has ever come back to us and said, we're going to extend that to a 40 by 60. No one from the inspection department, nobody. First thing we know, they pouring a slab. Ray Murray, Ray Murray down the streets, he's got pictures from start to bottom, from start to top. They laid the cement down, and they got the permit for that, I guess. Next thing he said, this big building's going up. And he called the city inspection, he said, that's too big, it's a commercial piece of property what they're running commercial out of a residential area. Now everybody knows that in the whole neighborhood. Jesus Christ, that's commercial in a commercial property in a residential area. That's illegal. No, I'm sorry, but that's the way it is. And I just don't like it. And if I had my say so, I'd be like that lady there, tear it down. But anyway, I don't know what else. Any
No, that's fine. Any questions?
I can answer all kinds of them if you want. They're all day
Appreciate your
long.
help. Thank you.
You're welcome. Thank you.
Is there anybody else here to speak in opposition? Mr. Mann, you got 3 minutes for rebuttal. Closing comments.
Mr. Chairman, members of the board, I guess just to make sure that we're clear, we dispute that anyone from our group, or that the Phelps ever told anybody this was just going to be a 3-car garage. That's not what we told them. No matter what has been said here today, I know that there's been a lot of history. I mean, we're down to 3 things. We're down to, we need to do the approach. My understanding is that there's just simply needed an approach, not a concrete drive all the way to the building. If that's the insistence of the group, then we'll have to address that. The siding on the property, if that's the understanding that has to be done, I mean, they've already started it on the north side. I mean, they can probably do that. That's probably, that's in a realm of an area that, in terms of a cost scenario, that they just need to do. But what we think is when we have a quality roof, recognizing it's not the roof they should have built. Frank's got a good point. There we go, complimenting each other, fine lawyer, and all of that. But I think that we're not looking to, they're not the type of people, nor do they have the resources to go after Menards. So they're trying to address this issue as best they can. Sure. They can't afford $20,000 to replace that roof. I just being around the city, I know that there are issues of sustainability that people keep talking about. Been to council meetings where they talk about sustainability, and steel roofs are part of that discussion. Now, what's not a part of the discussion is just doing whatever we feel like doing and defying the board. And I guess I'm here and I took this case because I wanted to be able to make the argument for this family that that's not what they were trying to do, and that we want to make sure that you understand that, and that we ask that you not require them to put asphalt shingles on that roof, because it will require removing and starting over again with that roof. And that's really, that's what we have. If you have any questions for me, I'm happy to address them.
No?
Dan, just a couple of questions, and I certainly understand this predicament. What I'm afraid we're starting to repeat here is the same problem you had in '07 when they didn't understand the building requirements. Then in '10, we said, here's what we want you to do. And you've stood up here today and said, well, we didn't understand that we had to pour the driveway the whole way. It's clearly written in there. That was clearly part of the decision. So even if I want to sit here and go, you know what, 22 grand, yeah, that's pretty expensive to tear off a good roof for nothing. You've planted trees, you know, it's looking better. But even if we say you can skip that, we still got a driveway that's not finished. And concrete's not cheap either. So are we just going to be right back at square one again where, well, gee, we saved 22,000 because we gave you relief there, but oh my God, I got 15 grand in concrete. Now are we back to square one?
Well, I think you have every right to ask the question that way in light of the history that we've provided you. I think you do. The only thing that I can say, that I will say, is that I've represented this family for about 25 days now. I intend to, you know, be in this city and be in front of this board many times in the future. And I'm telling you that, you know, it's not like I'm underwriting this operation, but I am being clear that if you know, make these kinds of demands upon these folks, that they have to get that concrete poured and they have to put that siding on, they'll do it. You know, if you tell them they have to put the roof on, I don't think they have any choice but to figure out a way to do it. I'm simply asking that you not impose that requirement with a perfectly good, because let me put it this way. I've made it clear to them that this is the third time you've entered the board, and you're asking for a modification of a modification.
Right. Yeah.
And that, frankly, a request I've never made before.
Right.
So I understand the predicament we're in, where we stand. We're simply asking that if they're allowed to keep the roof and they do these things, that you put a timeline that it get done. I know better than they do, at least than most, put it that way, that you have the authority, it's been mentioned, tear the building down. We know you have that authority. We're just simply asking that you understand where we are. We'll leave it in your hands and hope that you understand from our perspective where we're coming from. I think you've given us a good hearing, fair hearing, and we'll leave it at that. Do you have any other questions for me, folks?
No, thank you, Dan.
Thank you.
And we'll look to any last comments, questions for staff, and I have one.
Chair, members of the board, Sue Ann Donovan, Zoning Enforcement Office. This case has put me in a difficult position. I see Mr. Leo's complaint regarding this garage as not the shingles. His complaint is the size of the garage, which the board has granted twice. I don't feel that it's going to enhance Mr. Leo's view to have asphalt shingles on that garage. I think his main complaint is the size.
Okay.
I don't think that the neighborhood was ever misrepresented that it was going to be a 3-car garage, and that's not what was before the board the first time. So I don't think that in any way, shape, or form these people attempted to pull the wool over the neighborhood's eyes. I think if Mr. Phelps had appeared at the board the second time, or with counsel perhaps, we may have had a different outcome at that point. I think it sort of was outside of their, Mrs. Phelps didn't understand what the rules were. And granted, that may not be a defense, but she was operating in good faith. This would be an extreme hardship. It would be an extreme hardship for me as an enforcement officer to take this into court and make them remove a roof that is perfectly good.
Unless we're in West Des Moines or something.
Unless you're in the country.
Sorry.
So I'm caught between, I will do what the board requests, obviously. Obviously, I will. From a practical standpoint of what we take into court, it gets problematic at times to take something in that on its face may not be equitable. So if you have questions.
Yeah, the one that still just keeps sticking in my mind is, I have been told on numerous occasions that the board's decision and order goes along with the permit. Ms. Phelps comes in and says, no such thing was ever given to her.
I will tell you this. When I took this position, there were not as strict standards on issuing permits or having the board's decisions attached to the permits, and I have worked very hard over the last 3 or 4 years to make sure that happens. I believe it happens now. Now, whether it happened in '07, I can't say that. I did look at the permit online just now, and it said 17-foot height. It had no other requirements on the permit.
Okay.
So.
Now, who fills out the permit? Was that Menards?
No, that's whoever's at the counter.
Okay.
Whoever came in to ask for the permit, it was counter staff that would have filled out the permit.
So we don't know. Nobody, whoever's signature's on that, we don't know?
I don't know who filled out the permit.
The problem that I have is that, weren't they here in '07 because they hadn't got the permit, that they had gone out and they just started building this, and it came about?
No, that's not my recollection. My recollection is they came and asked for permission first. Then,
For that size of a building?
Yes.
And they were given that?
Yes.
Even without going to the board?
No, they asked for a 20-foot.
they came to you first.
But I thought in '07 they came because they had already been midstream.
They missed some inspections along the way as they began construction, if I remember correctly.
That's what I remember.
But I think that was the 2010.
Well, no, it was the footings. They got the building permit, but they didn't get the footings inspected at the proper time, and they were
They
done.
had not
Is that right?
started construction before they
Okay.
came in '07.
Right.
In '10, when they came back because it was too tall, there were some inspection things that we needed to straighten out.
Right.
But they didn't straighten them out.
Yes, they did.
On the footings and...
On the footings and the
Yes.
foundation.
On the footing?
Yes.
Yes.
Okay.
You granted a 17-foot, 40 by 60 structure in '07. When then they went, Mrs. Phelps went and purchased the kit.
Yes.
And it was constructed, and it was a foot higher than it was supposed to be. So they came back to you asking for relief on the height and relief from the asphalt shingles and the siding, because it was already constructed at that point.
Okay.
So they didn't start this without permission. They just somehow got sideways
And that's
after
what
the
brought us
construction.
in the first time.
In '10, yes.
Okay. All right, Sue, I appreciate your candor and your honest discussion here. That goes a long way for me. Have some trees been planted there since November 2010?
Yes.
Are those trees of a sufficient height that if they don't now, shortly they will provide some additional?
This is a photo. It's
Okay.
not real clear, but
No, it's not, because you shot this about 1 p.m. looking to the south, right?
I did not.
Based on the azimuth. Are those trees alive?
It's, last time I looked at them out there, they were alive, yes.
Okay, or if they want to nod from, yeah, okay, so the nod is the trees are alive, okay. So as these trees mature, do you think that they would provide additional screening of that structure?
Yes, and I believe that was the homeowner's intent.
Right,
Was to
and
try to
that was
mitigate.
our, but that was a directive from us. That was our intent, and those were installed and they are alive?
Yes.
Okay, all right, okay.
Any other questions?
Yeah, I have one. Sue, what's a reasonable time for us to require them to comply with the order of 2010? 6 months?
Generally, generally, the board's orders, they have 2 years to use them.
They've had
So,
2 years.
and yes, if you wish to, should you wish to not give them the variance today, you would give them whatever time the board deems appropriate, and we would carry on with enforcement under those orders. So if you said 6 months, the roof has to be replaced, we'll go out in 6 months and enforce it.
All right. Thank you.
Any last questions? Thank you, Sue Ann. Close the public portion and go to board decision.
Frankly, I'm not in favor of granting them any relief. I mean, if you want to continue this matter and see if the neighbors can work it out, I'm for that, but they were here in 2010. They understood. They didn't appeal it to district court, asking for equitable relief because they'd already built the thing. They decided to live with the 2010 decision. Why in the world should we change our mind?
I kind of agree. I've been thinking this through, and I've tried, I've listened to the neighbors. I've listened to just about everything that could influence me one way or another, and I'd rather see the neighbors work it out. I mean, if we want to give them a continuance next month to see if there's anything, I'm not violently opposed to granting it, but if they can screen it out, if they can make it appear not as bad, it just goes against my grain to go ahead and have decision ignored twice. I don't like it, but if the neighbors can live with it, I guess I can find some latitude in there. But I'd rather have the neighbors work it out. It's my thought.
Now, Mr. Chair, do we have the opportunity, depending on what we may look like we might be headed toward, to maybe get a nod from those neighbors who are here today, what they might think of a proposal? Can we do that?
Yeah,
No?
I'd rather.
Oh,
yeah.
okay, here's my take. When I saw this on the agenda, I was disappointed. We voted 6-0 on the way it was, and I'm like, why is this in front of us? What are people trying to do to us here? They got it wrong the first time. They came back a second time. We thought we had it straightened out. Now we're back a third. What kind of a patsy am I?
Yeah.
But in sitting here and listening to this, I see that there have been some attempts to work toward what we were asking for. We have the trees in. We have the paving started. I'm disappointed they couldn't, again, understand what we told them to do. Oh, I thought it was just the approach, not all the way up to the thing. But in looking at the big picture, if it appears to be a little bit of a rub that, well, we didn't think it was going to be this big, or we didn't think it was going to be this tall. Once these trees, even within the next few years, you're probably not going to see this from the street view. You can look at it right in the picture here.
Mm-hmm.
If it just comes down to, again, Long Beach, California, and some or neighborhood association with, gee, you have metal roof versus asphalt roof. I don't know if I want to throw them under the bus just because of that.
Mm-hmm.
In principle, I could. I could say, hey, I voted like this before. You guys didn't listen, sorry. Take your lumps and go home. But if I was inclined to say, you know what, it'd still be silly to tear this roof off. You're still then going to have the same height building. You're still going to have a roof. Mr. Leo will still have his same view of that building, which he may still not like. It's still going to be there. What I'd rather see is, I want to see that paving done to that gate by July 1st. And I want to see the rest of the paving to the edge of that door for that building by the next December 31st. And you go get a home improvement loan, you put up your equity, you ask your friends and family for money if you got to. But I'd rather see them spend it on improving the property that way than tearing this roof off. And I'm hearing my echo here while I say this. This is not normally what I would want to do. But I'm not sure where we'll be ahead, aside from the principle of the thing.
Here's my thought, Mel, and if you look around here, we're short 2 members. I want to treat both sides about as fair as we possibly can.
Mm-hmm.
And a 3-2 vote is not going to help anybody.
No, but there's 5 here, so maybe I'm the only one that thinks this way. I don't know.
I don't know, what I'm trying to do is take into account the possibility of a 3-2 vote. Okay?
Sure, which means she's stuck and it's over.
Exactly.
Okay.
I'm still, there's so many things that I still say I see wrong, but I like what Tom's idea is. If we can grant a continuance.
Okay.
We will have some more members, we'll have some more input, but if we're stuck on a 3-2 decision, we haven't done our job. That's what I'm getting at. So
right.
I would much rather see if there's a possibility that the neighbors can get together, the lawyers can get together, and if there's something that you can bring back to us next month that you all agree with, makes sense to us, it's a lot easier for us to vote 6-0, 7-0, than it is to have somebody sitting back there on a 3-2 vote and wishing that I should have done something different. Because 3-2 means you're going to change it back to what we said in November 2010. So if there's no objections here.
Well, ordinarily, when we have only a 5-member board and 4 affirmative votes are required, if the applicant desires to have a continuance, we generally will grant that.
I like that thought process, Tom. So,
Mr. Chair, could I add, though, and you can shut me down here? We have not voted on this yet. Is there any reason why we just couldn't reopen the hearing? I think the people that do care the most, that are against this, are right here in this room. Is there a reason why we couldn't say, hey, look, is it really the shingle issue, or is it the size of the building? We've already granted the relief for the size.
I think it's, in my view, it's, if there's people that are opposed to it, and we saw the consent, there's more than Mr. Leo here.
Okay.
So, I mean, we may satisfy Mr. Leo on this one, but if we had 3 other people here that didn't make it but sent out their card and we kind of ran over them.
Right.
He has to live with his neighbors, too.
That's true, yes.
Since we're on it, I will tell you, I did not want to have to put conduit in my garage. I was going to put drywall up, and it's a lot easier to run Romex rather than, so as I came crashing to the floor trying to put up a piece of conduit, I was burned up like mad that I had to do it, but I did it. It passed the inspection, but I got it done. So I've been on the other side. When being told what I got to do, I followed it, and that's because I have a neighbor that might. So that's what I'm trying to do.
And that's fine. I'm not opposed to that. I hope.
Okay.
Mr.
That's.
Chairman, if we do bring it back, could we include in our packet, I'd really like to see the paperwork from '07 when we were here.
Whatever you have. So,
Okay, good.
It's in there, right.
Is it in our packet?
It was passed around as an exhibit.
okay, I'm sorry.
It was,
no.
but you highlighted it in yellow and showed it there on
I
the
saw it
screen,
on the,
right?
Dan,
Could I ask something very, I don't think we've ever asked this or ever done this.
Yeah.
Could we go see this as a board?
I don't see any problem with, no,
we're always in.
All right, because that's outside of the formal hearing.
Individual, yeah.
All right, okay. But it's okay if I want to drive by and stop there on the street and look.
I would
Public meeting if you take more than.
recommend that people go individually.
Okay, that's fine, Mike. I'm not trying to upset the apple cart or anything like that. But, so there's a car parked on the street here in the next day or two. It might be me.
Or me.
Yeah. Okay.
Dan, you've heard the ongoing conversation here, and I think Mr. Clark's got a pretty good point. Would you be willing to take a continuance until our January meeting?
Mr. Chairman, on behalf of the applicant, we would.
Okay. And what I'm asking is, lawyers get together, neighbors get together. Let's have something that is going to result in a compromise that we can really easily vote on.
Here's what I'll promise you from our perspective, is that I will meet with Mr. Leo's attorney, and we will talk this issue out and and we will let you know exactly. We will make a concerted effort to talk all these issues through and try to reach a consensus, and we'll be clear with you if we were unable to do so.
I would feel a lot better. Because if you're going to make a black and white decision right here, it may not go your way. So that's, I think, okay. So.
And I want to add something on to the benefit of your client here. It says on the concrete drive, shall be paved with a maximum width of 16 feet. Well, what's the minimum width that you can pave so that you've got access to that garage? Can you have a single lane and then it flares out to the door? Does it have to be as wide as the door? Sit down with staff and figure that out.
And it actually says it only has to be to the north wall of the garage, so it doesn't have to be to the doors, it just has to be to the north wall.
Okay, yeah, and I'm assuming, is there an overhead door on that north wall so somebody could drive into it? Okay, well, I'd sit down with staff, find out what the minimum amount of paving is you need, because even with the apron you got now, you'll have to kind of shape that in. Come up with the minimum amount of paving and get a budget for that so you know what you're dealing with.
Okay?
Thank you.
There's.
Can I clarify, Linda, you wanted the board's action or the building permit?
The board's action, I'd like to see our packet from '07. Sure.
And I'd like to see the permit, too.
Okay.
To include that. I'll entertain a motion to continue this to the January meeting.
With the consent of the applicant, I move that we continue this matter to the January meeting.
Okay, do I hear a second? I'll second. All those in favor, raise your hand and say aye. Motion carries 5-0. Let's hope we can get something together. We really like to make this a win-win for everybody, so everybody, please work together, okay? Meeting minutes?
Move the minutes of last meeting.
I'll second.
All those in favor, raise your hand and say aye. 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 Thank you all very much. That was, I assumed Linda was an aye.
Yes, I saw her as she walked out.
Meeting's adjourned. Merry Christmas. Merry Christmas. And going over to AJ's.